Welcome again to the Close and Acumen. Welcome, Councillor Jay Ware. Good to see you.
Good to see you.
Welcome, ladies and gentlemen. Today is Friday. We'd like to welcome you and on this busy day in Liberia where the Supreme Court has ruled, on the current legislative uh, problem we have in that country. The Supreme Court came over ruling today. For some of us who are uh, not legally, not the legal minds, we decided to bring some legal minds here today who will help us to really carry out explain to us what the Supreme Court said today. So if you just joining us, we'd like you to just make your way here. Councillor Jay White is here with us. He's going to be helping us to interpret the ruling today because there's mixed stories around that, on both sides that are claiming victory. Tomalin is here as well. Tomalin, good to see you. But we'd like to welcome you guys. If you make your way, share the show. Share the show is going to be a great show tonight. Also, we want to remind you that as part of our annual giving back, we want to give to the guys in studio in Liberia. They've been a great help to us. We don't pay them. They've been generous to us, staying out late night to help us carry forward this show. So we want to do something for them this year, as we do every year. We want to give a gift to them that will help them and the family to have a good Christmas. We want to help them. They have made tremendous sacrifices for the closing acumen to go on. So we really want you to give if you can. In fact, a guy called me from Holland last night, and he said, "Dr. Peabody, I want to give a gift, and I'm going to send you a gift by Western Union." So we want to thank the young man for just being generous, for the thought of just wanting to give to help our fundraiser, to help the guys in the studio. If not for these guys, folks in Liberia will not understand, will not get the news and what's happening. But these guys have faithfully worked with us, even in the darkest hour. I want to thank Aliyu Kamara. He's in Holland. He called me last night. Said, "Dr. Peabody, I'm going to send a gift." But guys, we are happy that you are with us. Please share the show. We're looking forward to power-packed show tonight. I mean, a lot of people are coming with their own interpretation of the Supreme Court today. So we'd like to welcome you. Tomalin George, welcome, man.
Yeah, I want to say welcome to Councillor J.Y. Thank you so much for providing your time and your service, professional service to us to at least help our people understand what happened today at the Supreme Court in Liberia. A lot of people are turning in to watch, to listen to your perspective, and I think people from all sides of the debate are turning in to watch on YouTube, Facebook, and on our page, and live on the radio in Liberia. True FM is live on the radio right now, so speak. It's been carried live, and people are listening to it. So, and then one of the representatives from the other side, Representative Clarence Guy, will be calling in a few minutes to give his understanding of the Supreme Court ruling. We'll hear from him. Then maybe the councillor will take it from there. But in the meantime, we'll call him and he will tell us how he understood the Supreme Court decision ruling today. Supreme Court usually give opinions, they don't give decisions. So we'll hear from him in a few minutes. Well, it's good to be on the show, and thank you so much, Reverend Joe. I hope you are okay, your family is doing well, and all is well with you at your end.
Yeah, I'm fine. Thank you so much.
Okay. So let me call the representative, and then you hear from him, and then Peabody be talking until I get him.
All right, yeah. So let me just welcome some folks that are here. We'd like to welcome that are watching the show. We'd like to welcome you guys. All of you would like to welcome George Watkins Jr. District number 3, Montserrat County. He's watching us. We'd like to welcome Matt Huri, Chelsea Soiree. She's watching. Good evening, favorite panelists. Brian Sharif is following.
Okay,
Kelvin.
we got Representative Clarence Guar.
Okay,
He's on the line
for
from
them.
Liberia. He's from the majority bloc. Representative Guar, welcome to the closing argument, and we have Councillor Jallah is also on the set tonight. But we want to first say how are you doing and tell us how understanding of the Supreme Court decision, the ruling today.
I want to say thank you, Tomalin, and everyone in studio. Again, I want to say sorry. I was all set. I first did enter the studio, but due to our victory celebrations today, we want to enjoy ourselves because the Supreme Court has finally ruled, and we believe that the ruling is in our favor. On grounds that we didn't move to the court. It was former Speaker from Kofa who went to the court to seek legal interventions. And those provisions of the Constitution, if you saw the day of the argument, in a thesis statement of the Chief Justice, she made it clear that the justices of the Supreme Court were not concerned about what was happening at the Capitol ground, but were only diving into constitutional violations. Now, if you look at the ruling today, what the distinguished gentleman from Grand Crew County prayed the Supreme Court for, the Supreme Court never granted any of a wish. It implies that the majority won at the end of the day. So the ruling is clear. I don't know which better word I could use, but I can for the purpose of this, I would say the rulings ratings and understanding they are basically elementary that anybody could read it and understands what the Supreme Court said to the gentleman from Grand Crew. So the majority never acted out of the law. We acted in conformity with all of the provisions of the Constitution. So our actions were all legal.
Okay, everybody, you have any question for Representative Guar? And then
of course, Representative, welcome. Let me ask you. You say your action were all legal. So, are you guys going to return to the chamber? Are you all going to get together and see if you want to prefer your decision to remove the speaker? Are you guys going to go and meet in the chamber?
Well, why are you saying are we going to return to the chamber? Who determine which chamber? The legislature have 5 chambers. 2 is owned by the House of Representatives and 2 is owned by the Senate. 1 is owned by the John horses. So any of the chambers can be used by the approval and the will and pleasure of plenary. And plenary is simple majority. The decision was taken when the rules and order locked the door on us. So the majority, the plenary decided to use the John chamber as a place of business. The Constitution provides that the Senate and the House shall sit in the same city. And in this case, we are at the Capitol ground. So the first thing I want you to understand, I want the audience to understand, the Supreme Court failed to notify our sitting. You and I have nothing to argue about the legal basis of our sitting. And 2, the gentleman from Grand Crew County, Honorable Councillor J. Fanatic Kofa, was impeached. He went to the court and prayed at the court, and the court never granted any of the wishes. He's the former speaker. Let the record be clear. He's the former speaker, and Honorable Richard Nagbe Kun is the speaker of the 55th. Let that be clear. The vote, the resolution was read. We had 50 members who signed on that resolution, and none of those members has challenged their signature. No. So let us set the record clear that the gentlemen were impeached, and he's the former speaker. So he went to the Supreme Court and took a flat that he was unconstitutionally removed. So one thing I want you to look at, Dr. Peabody, is to see what his complaints were at the court, what he prayed the Supreme Court for, and see the ruling of the Supreme Court. He said in one of in argument that the Supreme Court should notify our sitting. The Supreme Court said they lack jurisdictions to do that. So what would you be discussing when we will go back on it? We can't the former speaker, how do we go back on it?
Okay, but the Supreme Court said today, okay, the court clarified that Article 43 of the 1986 Constitution emphasized that whether simple majority or small number is present, a presiding officer defined in Article 49 as the speaker in his or her absence. All right. So what will you say about that?
Read to the end. Read to the end. Don't stop halfway.
I just want to start right where it said the speaker.
No, stop on the end. I mean, read to the end. They said in his absence, in his or her absence, the deputy shall preside. So the fact remains in the ambiguity in the Constitution.
But he's not absent. You guys are the one appearing like he's absent.
Let him respond.
Peabody, you are not being a legislator. I'm a legislator.
It doesn't matter. I can read as well.
Listen to me. Listen. I'm inclined to this era more than you. So just listen to me. Let me provide the information to the public. So am I pretending to move on?
Go ahead. Yes, sir. Yes.
Okay. So this in the absence of the speaker, and there's what the ambiguity is. Even lawmakers, the speaker can be at the Capitol ground. Once he's not in session, he absent at that moment. Even members of the legislature, you can be at the Capitol ground. Once you are not in session, you are recorded as absent. So in the absence of the speaker, the deputy shall preside. So why the Supreme Court not notify our sitting is on the basis we had a deputy speaker who in the absence of the speaker acted as the presiding officer because he's elected. We have simple majority which constituted a quorum. So the basis for our actions were all legitimate. So the Supreme Court never notified our sitting. So again, read the rulings, and sometimes if you have lawyers there, read the ruling. Even Serena Seafor is now on Spoon Show. Once because the Supreme Court never compared the majority, it means that the majority actions were not illegal.
Okay, but my question for you, Representative Guar, that if the speaker Kofa gets his quorum on Tuesday, he gets his quorum to have a session, and the executive branch recognize him as the speaker, what will you guys do?
The executive cannot recognize. We have the media in which we communicate. We communicate through the clerical staff, the official person to communicate on behalf of the legislature, not Speaker Richard Kuhn, not any member of the House of Representatives, but rather the chief clerk. In the absence of the chief clerk, the deputy. They are being communicated to all of the panels that Councilor J. Funatikuva were impeached as speaker, and the plenary elected new speaker in presence of Honorable Richard Kuhn. So anything other than that, the other want to revise plenary decision, they need to have 49 going forward to impeach the man with a cause. So the decision has already been taken. Tomalin, it's not someone coming to discuss. It's not someone coming to compromise.
Well,
the decision has already taken.
I was informed before. I was informed earlier today that the president would place a call to the speaker, and some of the members that was on your blog said that they were only waiting for the Supreme Court decision before they go return to session. So now with the Supreme Court saying that the speaker is still legitimate, they're going to go to session.
No, the Supreme Court never said that. Read the ruling. The Supreme Court never said that. What he prayed for, the Supreme Court said they had no jurisdiction on that. The Supreme Court never said that. Read. I want you to read the ruling. The Supreme Court never said that. legitimate speaker. Anybody who interprets that the person is spreading a myth.
No, but the Supreme Court said that.
Are you a lawyer?
The Supreme Court said that the action of what you guys were doing was unconstitutional.
No, the Supreme Court not said that. That's why I said read it. The Supreme Court not said that.
Well, maybe you're reading something else, and
You're reading something different. No, guys, I'm sorry.
But too many. Bring the counselor on.
Yeah, okay. So, we have a constitutional lawyer here. Maybe he will interpret it for us. So, Councillor Jallah is a professor, is a renowned Liberian lawyer. He practiced in the Supreme Court of Liberia. He's a member of the Liberian National Bar, highly respected. And he has a law firm in Monrovia. So, he's here tonight, and maybe he will give us the interpretation of the Supreme Court, and maybe we'll take it from there. So, Councillor Jallah, representative, the guy is here. We got Jonah, Ben Jonah, and Peabody, and the Liberian public are listening.
Thank you so much for inviting me. I listened to the Supreme Court ruling, and I read its summary judgment. And I asked myself, who won this case? Did the Supreme Court rule in favor of Councillor Fonante Kofa? Or did the court wash its hands out of the entire process and say to the legislature, return to the House and make good consistent with the law, act consistent with the law? The Supreme Court said, using Article 66 of the Constitution, established that it has the legal right to hear any dispute that is connected to the constitutionality or the unconstitutionality of an issue. And so the complaint filed by Councillor Fonante Kofa, the court established that it has jurisdiction to hear it and determine whether the Constitution, any provision of the Constitution has been violated. The court, in doing that, it also held that the parties should return to the House and sort out which the law has not provided for. The court said the sitting of the respondent, which would be the minority black, and their actions were ultra-virus, meaning that whatsoever action they took, or where the majority black has been sitting, the court is saying that those actions and the sections are considered outside of the law. But having said that, the court did not proceed to request that the majority black return to section and honor the authority of Speaker Kofa, but asked the parties to go back and act consistent with Article 33 as provided for by the Constitution. The court went further and said that even though Article 33 talking about the minority, the House meeting, and the lesser member can adjourn from day to day for the full House to be in order. The court said there is no provision of law that requires that the court can compel the majority to return to status quo ante or return to the premises or the hall where Councillor Kofa and the minority group has been sitting, and left it with the legislature to determine whether they will voluntarily go there or they will not go there. The court went further to say that the court will not do for party litigant what party litigant has not done for himself or herself. The problem with that kind of ruling is that the press laid out by Councillor Fonati Kofa, there were issues that Councillor Fonati Kofa wanted the court to pass on or grant or deny. One, Councillor Kofa filed a petition for a writ of mandamus. Mandamus is a legal proceeding that compels a body to return to the rightful conduct of the law. In order for mandamus to be sustained, the court must state very clearly that the press, the items in the press, lay out, because Councillor Kofa said, one, that he was removed without being granted due process of law, and that act was unconstitutional, and that some members, I guess 3 or 4 of them, were removed from the committee as heads and replaced by other members of the quote-unquote majority black. And so Councillor Kofa prayed the court to declare that action was unconstitutional. And Councillor Fonati Kofa finally said that the external sitting outside of the chambers where his team was meeting, the court should declare that the sitting was unconstitutional, and that the majority by law should be compelled to return to where Councillor Kofa was sitting and conducting section on a day-to-day basis. Now, the court introduced two issues. The court introduced the question of the political doctrine question that says that the Supreme Court cannot review the legitimate action of the House because they are equal branch. And that the doctrine of separation of power will not allow the Supreme Court to grant the mandamus, compel the majority black to return to status quo antique, or return to the chambers that they were meeting where Councillor Fonati Kofa had been presiding as executive, as the Speaker of the House. Now, to my mind, and knowing all the justices on the bench, I would have thought that the court would have gone count by count to grant the prayer or deny the prayer of Councillor Fonati Kofa. It was not enough to invoke Article 66 and say the Supreme Court has power to hear and decide constitutional issue, but we don't have power to mandate the majority return to where Speaker Kofa has been sitting. And so that's why you have the majority are saying that since the mandamus were not granted, the prayers that Councillor Fonati Kofa laid out in his petition were not granted. The ruling is in our favor. That's the argument. And even the public, the court left the public to begin to argue that either Councillor Fonati Kofa won or the majority black won. The court, in my mind, would have said that the sitting clearly said that the sitting of the majority black in the joint chambers is ultra-virus and unconstitutional. Therefore, the majority black must return to the constitutional speaker in the chamber where they were sitting before. The court said nothing like that. Rather, the court said that it had no authority to compel the majority to return, meaning the mandamus was not granted. And that the majority can remain, in their own interpretation, can remain where they are. without returning to Speaker Kofa. So the whole issue returned to a political question and a political solution.
So I mean, the code just, the code confused. That's everything in confusion because
they could not confuse Tomalin. They could not confuse the code. Say you're going anyway by yourself. Let me just come back to a few clarity.
No, but you say you're one. You say you'll have one. That's what you said, Representative.
I said we won on ground that we didn't go to the court to ask the court to do anything for us. It was Honorable Kofa who went to the court that he was unconstitutionally removed. Our sitting were illegal. The court never granted any of the wish. So in that case, who won? You asked them to nullify all of our action. The court never nullified our action. So if my actions were taken in fulfillment of my duty that benefit my actions, and it was not nullified, I won. That's the package. But let me go back to say this. The court never notified our sitting. The Constitution provides that the Senate and the House shall sit in the same capital. And on this basis, we are the Capitol building. The court said any sitting or action by member of the legislature not in conformity with Article 33. Article 33 is in two parts. A simple majority shall constitute a quorum. And the lower number may adjourn from day to day and compare. So the first thing he went for the second portion to compare all in the Supreme Court interpretation and say Article 33, it means that the simple majority shall constitute a quorum to conduct business. So we have the quorum.
Okay, but let me ask you.
I'm coming there.
Okay.
Article 49 further when I say the speaker shall be the presiding officer. In your absence, the deputy shall preside. So we have the deputy presiding.
But where was the speaker absent? The speaker is still in the red chamber. So why you say he absent? What?
Who determined the chamber? Now you?
Oh, but not you either. You should know what a chamber is.
Let me answer that chamber question that they run away. Let me say this to you. We only do this to educate the public, but the argument of the gentleman to go to the court to nullify our city and the Supreme Court now granted a wish, you are not going to argue on which chamber is the legitimate chamber. Again, I will check for a communication that Speaker Funati Kofa wrote ECOWAS on the king. He acknowledged that any of the chambers could be used. He acknowledged that any of the chambers could be used by plenary. So if we decide to say we want to use City Hall, once in the capital, we can use it. The case of Snow and the case of this is different because the majority at the time of the removal of Speaker Snow were using Virginia. We don't honor the domain, the constitutional domain of the legislature to perform. But in this case, we are at the capital ground, the grounds of the capital. So again, the councillor in studio just maybe right there, what he prayed for were not granted. So our actions were already taken.
Well, let me ask you a question, Representative Guy. Okay. Question quick. They said in the Supreme Court, okay, the councillor will chime on it after you respond. They say wherefore in view of the foregoing, any sitting or action by members of the legislature not in conformity with the issue of Article 33 and 49 of the Constitution, that's the word, ultra viral, okay? Hence, members of the House of Representatives are to conduct themselves accordingly.
Very good.
Yeah.
So it says Article 33 say what? A simple majority shall constitute a quorum. So if you don't have simple majority to constitute a quorum, don't do business. It says
that's not what they that's
let us not interrupt the guest.
Mr. Representative, So,
Yeah.
so there is one thing of reading the law that I know you are reading. But one thing that was done today, the Supreme Court interpreted a particular piece, even though we all have been reading something that we all have read before. But this is what they said. They said that this court interpretation, so the court is telling you, let me finish.
Go ahead.
He's
So
not talking.
It said that this court interpretation. So what I'm reading, that's not what is in the court. It is the court interpretation for you and I. It said that this court interpretation of Article 33 of the Constitution of 1986 is that wherever a simple majority is sitting or a lower number, in both cases, a presiding officer is defined in Article 49. So they are telling you whether there's a small number or whether you have a big number. It says the definition of this definition is defined in Article 49. And in Article 49, who does it refer to as? Oh, okay. I thought you were just about to. And in Article 49 of the Constitution, it says the Speaker. So this is not what we are reading. This is their interpretation of what we've all been reading this week. They are saying that whether you small number or you get big number, it must be led by the Speaker. And they give you a reference to Article 49. And then you are saying that the Speaker is still not.
So I can
Yeah, come in.
Okay, let's go back to paragraph 3 and 4. Let me read it for the public and don't read it in parts. It says that the court interpretation Article 33 of the Constitution 1986 is that whether a simple majority is sitting or a lower number, in both cases, a presiding officer defined in Article 49 of the Constitution is the Speaker, and in his or her absence, the deputy. That in the event where the Speaker is presiding over a minority, the Constitution is devoid of the mechanism for how the majority is to compel the attendance of the absent member, and that the legislature has promulgated no enabling statute or standing rule forth setting forth the process for comparing absent members to attend in vision on Article 33 of the Constitution. That under these circumstances, the Supreme Court cannot.
Article 49 is not.
Ben, don't do that. Ben, don't do that. Let him land.
Nobody stop
Ben,
you can't
don't interrupt. Yeah, let the man land. Don't interrupt this man.
You're not going to turn the show. I'm not listening to you.
I have to leave the show and go my enjoyment. You hear me?
Nobody.
Yeah, but that's all you do in German, and you got the country in the limbo. That's all you do.
Yeah, but then you come something, you tell you that you can't have party. So it means I become a representative. I cannot have time for myself.
No, you can have time for yourself, but we're talking serious matter. You're talking about in German here, Representative.
But I'm telling you, I told Tomalin, I texted him that we were on a victory celebration, and he asked me to appear. So you don't kind of restrict me because I'm a representative. You think that I'm living with you?
You're not living with me, but I'm telling you, you're my representative, and you need to be serious about what we're talking about.
See, Tomalin, I'm a lawmaker. I may not be elected in a position. Then you keep quiet.
Wait, be like that in a position. I don't want to be like that. I don't want to be
It's the presidency, the legislature, and the judiciary. You get ministerial position because these are dream positions everybody want to hold. So
I don't want it. I serve my people in a different way. I don't want that. I'm not there to survive on my people. I work and help my people.
Then they got it when I come also we do that.
Go away. They've been very
how was it we get one more time we'll do that. I don't count the show now.
You have the Rudy, you want to interpret the Rudy the way you feel. And the Rudy is clear. The man pray for everything. He pray for the court, not brother. It means he got defeated. There's nothing about that. He got defeated. So there's nothing about me and you arguing.
So
you said the law is the law.
Someone, can I say something to the representative, please?
yeah, okay, Representative. Somebody want to ask you a question. Go ahead, Lofa.
This is Miss Representative God. This is much of a comment and not a question to you. I want you to take into consideration something that you probably are already aware of, but you are purposely ignoring that. You are an employee of the person who's questioning your activity. The man you're talking to is not being hired.
They respect me.
Okay, no, and I understand that. Regardless of that, you must also be cognizant of the fact that as an employee,
That's
you
what it do.
cannot also
You're not getting chance to talk, Lofa.
Can I
You
just,
were getting
Mr. God,
interrupted.
Mr. God, let me just land. I understand your position. I don't think his concern about your position here was in any form of disrespect. Disagreement is not a form of disrespect, but you must also be cognizant of the role that you, Mr. God, would you please allow me to land, please?
Yeah, getting chance to talk, Lofa. You see what I'm saying?
Mr. God,
Well, Lofa, let me talk. Go ahead, Representative God. Go ahead. Go ahead.
I'm a qualified Liberian with the exception of elected positions. I'm qualified enough to work anywhere. Why I'm serving you?
Man, you going about nowhere, man.
Do everything with respect. I have time for my
I had to just boast, big mouth.
Yeah. So if I wrote Tomalin at the time I came on the show, he was not available because he didn't give me the time. We are outside of British video. He said, "Oh, Clarence, I beg you, come on the show." And I came back and you don't want to give me that. What I said, I'm a national leader. I'm a national leader. On the show, and you want to disrespect me.
No, national, Mr. Representative, nobody respecting you, Mr. Representative. You just taking it out of content. You just taking it out of content, Representative, but nobody respecting you.
So, Mr. God, I review again.
I'm not taking out of content.
So, Mr. God, and I'll close on this note. Hopefully, you can address the concern that Peabody was actually putting out here. You, as the people's employee, I want to highlight employee. You're not an employer. The privilege. You should understand this. The privilege to represent your people is not a right. So when you come out here and make these outlandish statements about the fight. Mr. God, you see now you're actually exhibiting the true disrespect that you.
Yeah, okay.
Go ahead.
So can I, Mr. God, can I please land?
This to you.
Let the lawmaker speak.
This show and you show me disrespect. I will not take it.
No, we're not letting my disrespect you.
You will not be disrespected. No.
Let the lawmaker speak.
You gotta go to the issue that are involved. Gotta go to the issue.
Okay, Clarence, God, go ahead, speak.
Okay. All right. Go ahead.
Okay, Isaac Jackson, you got anything to say to the lawmaker?
Hello. Do you want me to come in now?
Yeah, come in.
Okay. Let me take this time to commend you guys for the show, and let me say good afternoon, absolutely, to Liberians and friends of Liberia that are following the show. I think today what we see on display is a victory for democracy, is an absolute victory for the respect for the supremacy of the Constitution and the rule of law. It's a victory for the petitioner, Councillor Kofa, because he exercised courage to do what he did. And I'd like to applaud the Supreme Court of the Republic of Liberia. Notably, the court in recent times continued to demonstrate or had demonstrated absolute strong judicial courage. I talk about judicial courage and I reference the court ruling against the government in the case of the tenure officers. The court exercising its judicial authority rule against the executive. It is not an easy thing for the court to do and the court did that. We must applaud the Yo's bench. I know Yo is fast moving towards retirement, but I think she will have a better legacy than Kehleboe. You know, Liberia have come a long way. If you read our history, it was our women, in many cases, that tower. You go to Brooks Randall, you go to even during the terrible days of our war year, they had to take Lehman Bowie and few good women who stood up that brought peace to Liberia. Those women someone had to scrape themselves naked in Accra, Ghana, to shame some of the men, stubborn men, to get them to do what Liberia needed. Justice Yo and the bench exercised individual courage, did justice to Liberia, to the law. And so I am happy tonight. It is unfortunate that the lawmaker who called has not taken time to read the opinion and to digest it. When the lawmaker asserts that everything that Kofa prayed for, he did not get it, the lawmaker is wrong. Completely wrong. For those of us who are lawyers and people who practice law, I don't practice very much, but many of my colleagues who practice law, they will tell you, even in America, everywhere, I went to school in Liberia and went to school in England, London, and I followed court proceedings in England, London, before coming to the US. The lawyers can go to the court and pray for 10 million things. It is the prerogative of the court to take what it considers substantive and rule upon that substantive issue. You can pray for 1 million, and maybe what the court will take and consider substantive will give you what you wanted. In this instant case, the court says something that was critically important, and that lawmaker have not taken time to digest it. The court said that if your conduct was not in keeping with Article 33 of the Liberian Constitution, and what Article 33 of the Liberian Constitution basically highlights? It highlights the issue of the quorum. It also says that if the minority, which would be right, which would be on the side of the law, if they cannot get a quorum, they should from time to time encourage the other people to attend. So the framer of the Constitution knew in their mind that something like that will happen, and bulk of the people will be in the wrong, and they will be absent, they will be staying away, but we had to compel them to come. The court talk about that. Now, when the court said that, on whose side you think the court was speaking? In today's ruling, the court did not even recognize in any serious way the majority bloc. Then the court also went on to say that if your action is not in keeping with 33, if it is not in compliance with 49, what 49 talk about? You guys will have a constitution be reading it. 49 talk about what? The speaker and the deputy speaker, but it emphasizes that what? The speaker should preside. And the speaker should be there for what? 6 years. And if you want to move the speaker, there are procedure, well-established procedure laid down to remove the speaker. The colleagues who are talking, he ain't reading, he ain't digesting. He talking the way he talking. The court said if your action was not in line with all of these things, then it is what? Ultra virus. Ultra virus is a Latin word or Latin phrase. People call it phrase, but even though because the 2 words that basically say you did something that's not within your authority to do. When the court said that, and that because the thing was not in your authority to do, and you proceeded in manner not supported by law, It is what? Void ab initio. You think the court was talking to Kofa? Brother, no. The court was talking to that majority bloc. Now, if their action, everything they did here, if it was not consistent with 33 and 49, then what they're doing is ultra viral. So when that lawmaker said the court gave Kofa all that Kofa asked for, just that alone gave to Kofa, the court using ultra viral, gave to Kofa everything he asked for. Because when the court say your action is ultra viral, it means everything you did is what? Void ab initio. It's illegal. It's of no effect. That's what it is. And I can appreciate that many of our people who are not lawyers will find it a little bit difficult to understand, because Supreme Court opinions are not meant for non-lawyers to interpret. It basically meant for lawyers to interpret. People talking Latin over there. You didn't go to law school. How you understand Latin to explain it like that? And you don't even get presidential cases under your belt to reference. And you understand it? So these court opinions are basically for what? Lawyers to interpret and explain. And even in other cases, those are all who been to law school, sat down there and learn some things, we can even disagree. But one thing that I think you should remind yourself, the lawyer representing the majority bloc, what was his first argument he put on the floor, which the court dismissed today? His first argument to the court was, this is a political matter, and I'm encouraging the court to stay in hands. The court got jurisdiction. Leave it. We political people doing political things. The court answered that question today in the affirmative regarding its jurisdiction. What did the court say? The court said, no, Article 66 of the Constitution says we should deal with what? Dispute. We are arbiters of dispute. Then the court stopped there. The court went to Article 2 of the Constitution. It said every decision we make here will be binding on everybody who lives in Liberia. So we got jurisdiction. We'll look into this in the case. So the court established its authority. Why it should look into the case? How can anybody argue that the court give Kofa judgment when the court even reference how they call it, brother? The other thing, the way I will explain this, it's a sophisticated ruling. I will try my best now to explain this sophisticated ruling in a more sophisticatedly simple manner by drawing a parallel. Since other of us here are adult, and our lawmaker who call, I show he's an adult, I show he married. I will draw a parallel to divorce. The parallel with divorce is such that if you and your wife get issue, two of you living in the same house, and I'm coming down, so I don't want to get into sophistication anymore. Both of you are living in the same house. And if you got confusion and you really displeased with your wife, you move into one room in the house, and then you go and tell people, say, that woman, I don't want her again. She must get divorced. You think it's acceptable? Even if you and your wife got issue, and you get so angry and say, I'm moving up to my crowd border, I'm going to my man. In fact, I'm moving from Minnesota, I'm going to Peabody, I'm going to Tomalin. So I don't want that woman again. I'm going to Peabody, I'm going to Tomalin. I don't want that woman again. You think it's acceptable? No. Now, what a lawmaker then did, you and Kofa sitting down in plenary, you got the chamber to sit down in and make business. You get very with Kofa, you jump from there, you go in one different room. We don't want that man again. That man, I'll speak about, we don't will put Kun there. No. The same parallel with divorce. If you want to leave the woman, separation is not tantamount to divorce. You must file a divorce petition. And that petition must contain your complaint, your charges against the woman. But you can't just say because you fell the woman, you go in one room, or you fell the woman, you go from the you go to Tomalin, or you go to some of your friends, then say you leave the woman. It doesn't happen that way. Oh, I draw this analogy to explain to Liberian people what the court is saying. The court is saying to the other 43 guys, there is an established precedent by where you can move the speaker. You don't just go to different places and say, oh, we don't want the speaker again. You must go into the plenary, which Kofa Post also highlighted that, gentlemen. You have to come back to work. And if you guys insist and don't really want me, I will find my exit. I will find a way to get out of these things. But we got to respect the procedure by which we can move our speaker. And what's the procedure? The procedure is basically you go to the plenary, somebody will file a motion for the speaker to recuse himself on account of the accusation against him. That's the procedure. The speaker may recuse himself. We saw this with, how you call this case? Nukwe with, how you call it? Ellis Tyler. I saw the video training on Facebook. Nukwe exercised that courage, sat in the plenary, filed a motion against Jenica Jallah. He said, this speaker here is now a criminal indictee and he will not continue to preside in the house. I move, if I can obtain a second, that he recuses himself. That's how Ellis Tyler struggle started. And I'm going to go in different room. For the 3 minutes, why don't they come to plenary, exercise that same courage, look Kofa in the face and say, on account of these charges, Mr. Kofa, your gavel is tainted. You can no longer preside. Step aside. Kofa will step aside. The committee will be constituted, and then an investigation will ensue. And following that investigation, if Kofa is wanting, they will come and say, Kofa is wanting. Then you can now come with a so-called resolution now with the tutor in question. But the tutor is condition subsequent. It's not precedent why they're doing so. It's just everything they did was just wrong. And that's why they could use ultra-virus. I'm sorry, somebody interfering and knocking the door. Yeah, let me check there quickly, okay? 1 minute.
So, that person do.
Start talking.
Even y'all need to check that mail. Please.
So the rule for no.
Representative God, yeah, we hear you.
Okay. Again, I listened to Ansu Jackson, and is
so we're they're not making a good ruling. They're not rule for Kofa, they're not rule for the majority.
Hello?
Yeah, go ahead.
So I think everyone was quiet listening. So let me just take the issue. I think I listened to Ansu Jackson well, and he said in his opening statement that he has not been practicing. So I understand from the background, his interpretation has been personal. But let me just reference it to the lawyer that is in the studio there. You reference, I missed the counselor name, but I will just reference him as counselor.
Counselor Jewel.
Counselor Jewel. I stands to be corrected. He said the Supreme Court never gave a definite ruling. This is what he said. He said, I stands to be corrected. What all Kofa prayed for, the Supreme Court never granted any. Like the same I said. So when Ansu Jackson is coming, a senior lawyer is on the show, and he contradicting himself and feel that the senior lawyer is on the show. Similar opinion expressed, it may not be word for word, but he expresses similar opinion too. But let me just come back and make the reference between the Tyler case and that of the Kofa case. When Nukwe took the courage to raise the motion that Tyler should recuse himself on ground that he has been complicated with criminal matter, and Tyler refused, it was on that basis the majority moved to the John Chima. In our case, when we went to work on the 17th of October, prior to the 17th of October, the speaker then, former speaker Funati Kofa, wrote in the chat room that there will be session by 4 o'clock. I pay for private flight to come. Our rules are clear. Any amendment to any portion of the rule required to take. And Speaker Kofa at the time never had the authority, not even Speaker Kuhn or anyone had the authority to decide when plenary meet. We went to session. And Honorable Cole, the former rules and order chair, locked the doors, brought talks which were in violations of Rule 42.2. It reads in all, no member shall insult abuse or harass other person within the comfort of the house, or cause disturbance to the activity of the house. He took nail, locked the door, the videos are there, prevented the presiding officer as of the time who are the deputy speaker from entering the chamber. Locked the door, brought talks. On that basis, it's equivalent to the same as Tyler refusing to recuse himself. It was on that basis the majority decided to move into the joint chamber. Again, if you look back, the Supreme Court never nullified our action. The Supreme Court said any sitting or action of the legislature not in conformity with Article 33. What Article 33 says? A simple majority shall constitute a quorum, but a lower number may adjourn from day to day and compare. So we have a quorum. Let's go back to our rules. Rule 13, Rule 12, 13 speak about quorum. Rule 13 says when there's a quorum established, when there's a quorum established, the sergeant at arms shall cry for the commencement of their business, followed by a prayer from the chaplain. So it laid down the basis in which session could be called to order. Now, we have the sergeant at arms. We have the clerical staff. And Ansu Jackson should not come on the show. You already say you won't practice him. We have contacted constitutional lawyer. The Councillor J is on it. Maybe I'm missing a name, but Councillor J.Y., right?
J.Y.
Councillor J.Y.
J.Y.
Councillor J.Y. is on it.
Jim West, don't spoil a man named there.
Yeah,
Ain't no own lawyer need a serial man.
So the ruling in entirety, what Speaker Kova went for to be granted was not given to him. And the court, if you read the opinion, if it goes further down to paragraph 4 and 5, the court said, under these circumstances, the Supreme Court cannot do for the legislature what it cannot do because the legislature never created a statute or any rules that laid down the procedure in which the minority could compare the majority. So on that basis, when the majority is sitting somewhere, the majority don't have no legal reasons to call them. So if the Supreme Court said they cannot do for what the legislature cannot do for itself, it means that they deny you to compare the majority to return to you. So like I understand from where you speak from, he has not been practicing. So at least what I said.
And you have been practicing, right?
Not that. But why he said he has not been practicing, and that means so. So in part, there's a senior counselor there that what the senior counselor says should be superior than what Ansu Jackson is saying. Again, Ansu Jackson, there's a legislative matter. If you
may I respond to him because it's becoming very erroneous and comical.
No, I'm not becoming. You have to give me a chance, my man. You talk all your time. Nobody interfere.
No, I got interrupted by my colleague here. That's what I want to attend to him. I didn't learn my thoughts. Let's be fair and honest now. I didn't learn my thoughts. I asked because somebody was knocking the door.
Let him finish, and then you again. Yeah, you guys are the.
I was given the time. I didn't rush to
okay, you have the time now, sir. Go ahead, continue.
Mm-hmm. So whatever, the interpretations were done by a senior counselor on the show. And that supersedes the opinion of an Antonia law. There's a senior constitutional lawyer. And there's a political matter. There's a political matter. If you made reference and said that the treatment of Tyler refusing to recuse himself on ground that the majority moved to the joint chamber was legal, the actions of the speaker to instruct the former rules and order to lock the door and prevent us from going violated rule for the 2.2 of our standing rules is equivalent to the same action of Speaker Tyler refusing to recuse himself as of the time. So again, the the doctrine of separation of power and came into full swing today that the Supreme Court cannot interfere into our business. It's clear. There's nothing more the Supreme Court will have said. So again, whatever we say on the show, that just for it, but we will go in the theater, the mayor is a former speaker. There's nothing you can do.
All right, thank you.
To compare them, but nothing you can do. He has been impeached, and there was election held, and the new speaker was sworn in. I can tell you, at the end of the reading ruling from the Supreme Court, we will ask that other the immunities that he enjoyed because of the prohibition should be removed from him, and he should not enjoy one immunity as speaker because he's the former speaker.
Thank you, Representative. Thank you, Representative.
Let me not lend my thoughts.
So Tomalin, I beg to excuse you, please.
Okay.
Yeah,
Okay,
go ahead.
Okay.
Let me not lend my thoughts on what the lawmaker just said. I think the lawmakers is dishonest. And to be fair to our Liberian people, I think we must not tell the lawmakers, those who created this mess that Liberia is witnessing, for which we are becoming a laughing stock in the sub-region. I think we should tell them it is about time that they sit down and keep quiet and stop confusing the public further. When you hear the lawmaker, I'm being earnest. I mean, like I'm in America. I'm not in Liberia practicing. So if I make an honest statement that while you will hop on, my education is diminished by virtue of the fact that I include every day in the US, is that the logic that lawmaker is trying to propound? You see the problem with Liberian people when you try to be earnest, they hop on it and say things that are just egregiously wrong. I went to law school in Liberia, practiced briefly, went to the United Kingdom that had a superior judicial system and followed them. At least respectable system. You lawmakers who have been accused of being influenced by bribe money, disgracefully camping at a hotel, you have moral authority to come on the radio and further confuse our people? You want somebody to respect you when you engage in the conduct of gangster raising? What he's talking about is all it's going to be in the allegation that Speaker Kofa instructed somebody to like do. You hear say, now aware, Speaker Kofa, I'm not saying he instructed the person in question, but even if it is part of their claim, these allegations must be put to the doorstep of the speaker, and he must be afforded time to answer to them. That's why the court talk about what if you want to remove your speaker, there must be a cost. I'm interpreting what the court is. I took case to that Supreme Court. My name is on the Supreme Court presidential docket. Does he have that courage to do what I did with the CDC government? You see the problem with some of these people? Look about somebody here, a senior counsel here, a senior counsel here. What do you know about senior counsel? You don't know anything about senior counsel. Correct? So he should stop. Those who created a mess, that embarrassment for Liberia should stop. They should sit down. They should keep quiet and stop embarrassing the country. You know, so what he just said about somebody liking though, it should be part of their complaint against Fanatic Kofa. What I drew is quite parallel with the nuclear and talent thing, because it started with what? Observing particular precedent, particular practice. They went in they went in the plenary. Unlike their case here, where Kofa is traveling with the president in room. And then you guys are running away, going in one different room and saying you're doing something. That's how it started. It was not a plenary session that you were attending and a motion was brought forward containing these allegations, and Kofa said, no, I will not honor it. No, it was not it. Stop deceiving the public. You ran away to a different room and Kofa, the minority, and in fact, you tried to even misinterpret Article 33 of the Constitution. It was Article 33 of the Constitution that the Supreme Court made reference to when it's talking about what? Compelling other people to come to session. The minority should compel the majority of people who are in the wrong, who are ran away, the runaway lawmaker, to come to session. The court said that element of our law, you guys have not made any law to qualify the compulsion element that you compel the law-breaking lawmakers. It's ironic, right? You're a lawmaker, you're breaking the law, you're not seeing, you call on telephone and talking garbage. The court just said in passing that, look, ever since you people should have made, at least establish a procedure by which you can compel your majority friends when they are in the wrong to come to session. It does not give you green light, or it's not a validation that you your so-called majority blood is right. No. The court was just expressing its little frustration, encouraging it that if this crisis is over, you must now pass a law by which, when the vast majority of people are wrong, you can force them to come to attend session. One of the things Kofa done cleverly is following the court's ruling is to be subtle and diplomatic and say, look, gentlemen, you gotta return to work. Have you read the statement coming from Kofa? Very educated man. Unlike the man you buy into today, who doesn't even know which hand to pull off when he's taking oath. Is that disgraceful? Lawmaker, you go into a coon who doesn't know simple things, which hand to pull on to swear oath. Is that not embarrassing for you? You're not even embarrassed by the fact that there is a huge allegation that some of you are being induced by bribe money for which you came in a hotel to remove a speaker. Are you supposed to come in a hotel, Mr. Lawmaker? Are you talking about, what are you doing? You know, the problem with some of our friends, they don't have the capacity to be shamed. So it's a problem. How do you shame a shameless man? That is the problem. Because some of these people are shameless. Some of these people are shameless. I drew a parallel with Davos proceeding because I wanted to provide a simple explanation. If there is a confusion in the lower house as it is now, you don't just move from there, go to different room and say, oh, we let the other man here, the other man is removed. It doesn't work that way. There's a procedure. Let's follow the procedure. Your own rule you've been violating. Let's follow it. Was the procedure followed? The court said no. The fact that these things were not done, the action is ultra-virus and void ab initio. It's of no effect. That's what the court said. I don't know what other explanation somebody has provided, but I think it's simple. The court has effectively ruled in favor of Kofa. The person who called, is he saying to us that the court recognized Kun as the speaker? Is that what he's saying? Is that the thing he's sleeping on?
So, Sir Anthony Jackson.
No, it's not. Yeah, go ahead, Lofa.
Yeah. Just quickly, great, Louis. We appreciate your view on this. Again, this is coming from. Again, this is your profession, so we would like to hear from Councilor Frederick Jallah on this as well. Let's hear from him, get his view as to what he make of the ruling today. You're muted, sir.
Am I okay now?
Yeah, okay. Go ahead.
So I was saying the Supreme Court did actually not do justice in this matter.
How so?
The court was not called upon to propound on what Article 66 says about its authority for judicial review. The issue before the court was a mandamus proceedings to compel the majority, quote-unquote majority black, to return to the speakership and the hall where Speaker Kofa sat, along with the minority. The Supreme Court said that the sitting of the majority in where they found themselves was ultra-virus. But having said that, the court went ahead and said that even though that is what the situation looks like, this court cannot compel the majority to return to the speakership of Councilor Kofa because there's no law that says that. When you say that, you're saying that the doctrine of separation of power prevents the court from clearly stating that the majority had no right sitting where they sat, and that their action to sit outside of the chambers, recognized chambers, of the House of Representatives being ultra-virus, the next sentence must be that the respondent must return to the authority of the House. That authority is the presiding officer, which is the Speaker of the House. If you don't say that, and you are saying then that the mandamus proceedings are pending before the court, if you say that you cannot grant the compelling request from Councilor Fonante Kofa, you are saying that the party returned to where they were without any authority of Councilor Kofa to compel them to his chambers where the minority is sitting. Now, let me tell you about Article 33, the essence of Article 33. Article 33, as stated and as framed, was meant to ensure that where there is normalcy, where the House, some members of the House or the Senate continue to be absent, and there's no conflict, the minority will from day to day compel, adjoin, and request or compel the absent members to appear and be part and parcel of the whole deliberation. But instead of the court doing that, the court only established firmly that it has jurisdiction to discuss and decide constitutional issues. That is not a dispute at all. Article 66, the authority of the Supreme Court, and Article 2, that says the decision of the Supreme Court is binding on the whole of the Republic of Liberia. That's not a dispute. The dispute is, did the majority sit, or where the chambers in which the majority sat, was it legal to have sat there? Was the removal, the quote-unquote removal of Councilor Fonante Kofa as Speaker and the election of Kun, as they refer to him as the current Speaker, was that constitutionally done? The court stopped, instead of concluding and establishing that the actions were unconstitutional, the respondents are hereby ordered to return to the speakership of Councilor Kofa. The court said, your return, you guys go back to legislature, go back to where you were, and decide to basically make a law. And the court also said that, look, what a party litigant has not done for itself, the court will not do for that party litigant. That's not what the question was. The question was, all of the action taken by the majority, did it meet constitutional test? And if the answer is no, as the court rightly answered, then the court must order the party to return to status quo ante. The court never did that. So it left the majority to argue separately on the ground that they won. And then those who support Councilor Kofa will argue that Councilor Kofa won. If you follow this case, you will see Councilor Kofa and his legal team started first off by filing a prohibition proceeding. The justice in chamber declined to issue the writ. Then Councilor Kofa, lawyer represented by lawyer led by Councilor Janet, left the court, and then they decided to file a madama proceedings, which means compel the majority group to return to the gavel of Councilor Fonante Kofa. While that was pending, they also filed an in re. The action of removal of the committee heads were also unconstitutional. What stopped the Supreme Court from saying that having the majority having acted outside of the law is hereby ordered to return to status quo ante, meaning return to the chamber where Councilor Fonante Kofa and the majority sat to conduct affairs. All the court said was that there was no law to compare them. So what is the court saying?
If I may just ask my colleague a quick intervention question, if he allow me, I can intervene quickly to ask a question or to explain something.
Go ahead.
Go ahead.
My colleague says something which I think, if the court says that the court cannot be redundant, the colleague just testify on this public record that the court said to the majority that the setting was what? Ultra-virus. Now, do you counsel, will you go to your client? They are not your client, but let's assume they were your client.
They're not.
Let's just assume we all admitting that they were your client. But assuming and we all admitting that they were your client, will you go to them and say, you're sitting here and this court, the powerful court had declared your sitting here to be ultra-viral. So continue to sit here, or you advise differently.
Let me answer.
You see?
Yeah. I have 32 years of practice of law in Liberia. 32. That means that I've sat in, participated, read decisions or opinions of the Supreme Court. This decision today does not say who won and who did not. They put aside to say, look, the sitting of and when the court said the sitting of the majority is they were acting outside of the law, acted as if to say that they are not following what we call it Article 33 and 49. That was correct. But what stopped the court from saying that being the case, the party, the respondent must return? What stopped the court from doing that?
I think if let me answer that. To answer that, you see, when we come to public radio, I think, and like I was saying, when I started the conversation, I said to all of us that, these issues sometimes, even lawyers will disagree about it, but it is important to take common sense to a higher level because the reasoning of the law is what commonsensical. If you are sitting somewhere and the Supreme Court, I think the court didn't want to be redundant and overly simplistic. The court is interacting with lawmakers. The court tried to be a little deferential so that it doesn't go like many other people would think, but why they can't do they want? But if you are sitting in a place and you conducting yourself in a manner, and the court said to you, uses this Latin word or Latin phrase and say, your action or your setting is ultra-virus. It's a Latin phrase, which means what? You're acting beyond your authority. You're acting in a manner not really supported by law. What do you think the court say? The court basically just saying what you're doing there is wrong. It's void ab initio. You must come to the real timber. You must come to plenary and then carry on the action you intend to carry on. And they are procedure. They are constitutional, well-established procedure you must follow in removing the speaker. That's all the court is saying. The court leaving that way the people in the legislature to be reasonable enough. If I was sitting somewhere and the court say where I'm sitting is ultra-viral, you think I won't remain sitting there? If I remain sitting in that place that the court considered to be ultra-viral or the conduct that considered to be ultra-viral, I will be acting in the manner of a gangster. And I don't think the lawmakers want to conduct themselves as though they were acting in a manner of gangster. They want to be law-abiding. They are lawmakers. Their setting has been declared to be what? Ultra-virus. The only respectable thing to now do is to oblige. Come back to the plenary, go to the chamber, let's do business. Like what Kofa said, let's come back to work. Let's do it the right way. I think the court is just appalled that the mechanism, the manner in which they try to remove Kofa, is just clumsy.
Attorney Jackson.
It's just clumsy.
Attorney Jackson, the Supreme Court is not a party to any matter. So it doesn't feel sorry for the respondent or the appellant. The court has little or nothing to do with that. This court cannot say, look, if let me just throw in where there is an ejectment proceeding before the court. If the owner of a house, Councilor Jallah is occupying my building without paying rent, his law office is there without paying rent, and I'm sued. The court will agree. The court comes and agree that Councilor Jallah is in this building and he's not paying rent. The court stops there. That's what the court did today. The court will not stop there. The court will say, Wherefore, and in view of the foregoing, Councillor J.Y. is hereby ordered evicted. That's a clarity that the court will say. If you say Councillor J.Y. is occupying the premises, he has not paid his rent, the plaintiff is correct to seek an eviction order. What did the court? Why wouldn't the court say if the court stopped there?
No, the court grant the plaintiff the right to remove you. That's what the court will be saying in effect.
Oh,
And that's what the court did in the instant case. The court is saying to us, J.Y., so that's what I'm asking you, right? What will you tell your client now? Your client who's sitting has been described as ultra-virus. What do you tell them? To continue to sit there?
I don't represent them.
No, assuming we're all admitting that you were representing them.
No, I can't.
What would be your advice to them continue to dally into ultra-virus position?
I would
say that the court has already declared as ultra-virus?
I would say to the public, the court has delivered a pretty confusing decision. The court has not been able to say the party is. Look, I read the court when it went all the way down to where it says ultra-virus. And then what did they say? The court said, oh, having read Article 33, that say that a simple majority can continue to compel the absent members of the House to be present. We don't have a law to compel them to be present. So go back and enact a statute to determine how they will be compelled to come back. So where are we? At the same level, with the majority saying that we are correct where we are sitting. At the same level, with Kufa sitting down and saying that I will adjoin. Look, I know all of the justices on the bench, all of them. The only person who might have been who might be out of law school before I got out was Councillor Yo, Chief Justice Yo, and James Sutter Howard, what do you call it? And the rest of them, either I graduated before them, or out when they were still students. I know how very meticulous, I know how transparent they are in terms of making decisions. Take Kaba, for example, Justice Kaba. He's one of the most the oldest trial lawyer in trial judge in Liberia, apart from Justice Margaret Wright. What did they do? They thought to hang the case. They thought to make a decision to ensure that the public will interpret in a different way. Council Kofa will interpret in a different way. What will happen in this matter at the end of the day? It goes back to the politicians. And the bribery that you are contending about will occur. And you think Council Kofa will survive?
Let me say that. Let me say that quickly. Let me say this. He said two things that I found a little problematic. In law, we respect seniority, right? And so I like to acknowledge the fact that he said he's been practicing for I think 20 some more years.
22 years.
32 years.
The counselor who represented the majority black, I will call them so-called majority black, is a senior counsel who taught me law and taught even the counsel who was arguing against him, and I think made a better argument. Arthur Johnson and myself were classmates when Councillor Van Shemok taught all legal corporation. But Councillor, when the law is on your side, it matters little whether somebody is an old lawyer or is a new lawyer. What will be on your side is the law. In this instant case, the senior counsel has just said something that I think I found problematic. He said the lawmakers.
Jackson,
yeah.
Please, we got another councilor want to make an intervention. So since you on the show, you have the time. Can you? Arthur Johnson want to make an intervention. Go ahead, Councilor Johnson.
Okay, Tomalin, thank you, man. Councilor J.Y., how you doing there?
Councilor Johnson, how are you?
Members of the panelists, yeah, how you doing? Anthony Jackson, how you doing, my brother?
I'm very good. my accent out of Liberia had deprived me of sitting in the bar, so my mentee, I don't know what I'm doing, but at least I know what I'm doing. Because I hold a distinguished master degree. But go ahead, Arthur.
Yeah. Let me just make a quick intervention regarding, because I'm listening to the discussions. I think one of the problems I'm observing, especially from the senior counsel, Councilor Jewett, has to do with the following of the details of the reading of the Supreme Court's opinion today. And that to hear the senior lawyer saying that the Supreme Court was not clear on the issue of the sitting and the issue of the constitutionality or the unconstitutionality of the sitting of the so-called majority bloc, I think there is a need for us to make some interventions. As a lawyer and lead counsel on behalf of the speaker, there were issues that were raised, like Councilor Jackson was saying. It is the prerogative of the Supreme Court to decide, which Councilor Jewett knows very well, to decide which issue that the Supreme Court fees or any court fees when it is determining the matter, to make a determination that will be able of the controversy before the court. And one of the things the court can do is that when the court decides to develop or raise a particular issue growing out of the exchange of the pleadings of the party, the issue might likely be in the form that it will consolidate almost the crux of the matter. And that is substantially what the Supreme Court did today. That's you were very much correct. The law's interpretation was not meant for non-lawyers to do. The writings of the court, the writings and the opinions of courts are meant for lawyers to read and interpret for the layman. The law, technically, we all know in the era of the study of jurisprudence that the interpretation of law was not meant for a non-lawyer to do. That's not a non-lawyer job to do. So it is the work of the lawyer who reads the opinion and what the opinion is or explains what the opinion is to a lay person. Irrespective of whether that layman, that person has a doctoral degree or master's degree in different era. One, it is not in the law, he's a layman. Now, the issue of jurisdiction that the Supreme Court heard today, which Councilor Jewett said that the Supreme Court, that was not the issue before the court, I'd like to respectfully disagree. In the pleadings that we filed before the Supreme Court on behalf of Speaker Kofa, the respondents who were the majority black, their lawyer, Councilor Sherman, raised the issue of jurisdiction under the doctrine of the political question. In other words, for the Liberians who are listening, Councilor Sherman was saying that the Supreme Court has no jurisdiction get involved into that matter. And that argument was stricken down.
And the Supreme Court agreed.
Pardon me?
And the Supreme Court agreed.
The Supreme Court disagreed.
Go ahead, Councilor.
In the ruling today, the Supreme Court raised two issues out of all of the cases. And the third issue went to the crux of the very foundation of the members of the legislature who consider themselves to be the majority. First thing was for the Supreme Court to establish whether it has its own jurisdiction. We all know as a general law or practice, when the issues of jurisdiction are raised against a court, the court must first examine itself to determine whether or not it has jurisdiction. And so when Councilor Sherman raised the political question doctrine and said that the Supreme Court cannot get involved in matters because what is happening at the level of the legislature, specifically the House of Representatives, is purely political. Our argument was, no, it is not political because all of what is happening today in the case that was ruled by the Supreme Court is the same as the Edwin Snow case. The issues that were raised in the Edwin Snow case were the same issues that were raised in the Kofa's case. The issue of jurisdiction. Supreme Court don't get involved. And the Supreme Court said under Article 2 of the Constitution of Liberia, they said that they gave the supremacy of the Constitution as the organic law. That any law any decree, any action that is carried out or custom that undermines the supremacy or that is inconsistent with the Constitution, is to the extent of its inconsistency regarding, and then they said the Supreme Court shall be the one to interpret and declare any act or law to be unconstitutional, on Article 2, the subparagraph 2. Then an extension of that authority, for which indeed our argument was solidified by the ruling of the Supreme Court on that question of jurisdiction, is said that Article 66 confirms of the Constitution on this court to assume jurisdiction on legislative actions that border on issue of due process of law. So the contention of Sherman was defeated, or the majority black was defeated on the basis of jurisdiction. That was the first defeat in the ruling. So to say that the court was not clear, then I think I respectfully disagree. Then on the second issue.
Can I ask the council a question?
No, let me just learn quickly, then I just wanted to say something. Intervention is very important. And the reason I'm saying it's important is because I think there is a propaganda ploy by the majority black using a lot of social media blogs to say that indeed Supreme Court did not say anything, and that is wrong. Especially for lawyers who practice before the court. I saw one of my colleagues, I learned that one of my colleagues even appear on Spoon tonight. But the only reason I could not appear on Spoon because I can't appear on Spoon. That's all. But indeed, it was something that went to me because he did not read the opinion. And I sat before the 5 justices today to listen to the opinion, and I have the opinions and the rulings. And we all know the ruling is different from the opinion. Then, the Supreme Court said today that whether the issue of the sitting, the issue of the majority black is constitutional. How did the Supreme Court say that? The Supreme Court said it in substance by saying, they say any sitting by members of the legislature, specifically the House of Representatives, that does not conform to Article 33 and Article 49 of the Constitution, that setting is octod virus. And when the word octod virus is used, it means the setting is illegal.
Did the court grant the madamas? Did the court grant the madamas?
No, not madamas. There is no madamas that have been determined by the Supreme Court. We filed madamas. I filed the madamas. But the justice in Chimbo did not even cite any of the parties on that yet. Because we have not gone there to ask the justice in Chambers to assign the madamas. We filed the madamas there. But he had not assigned it yet. He had not assigned it yet. I filed the madamas. And there is another in repetition.
Councilor Kofa, so what else you will say?
There is another in repetition that is specifically on the issue of the illegal removal of Speaker Kofa that is yet to be determined by the Supreme Court.
Councilor Johnson, I'm asking you, you are a lawyer for Councilor Kofa, so what will you say?
Pardon me, on what?
You are a lawyer, you are the lead counsel, I think, for Councilor Kofa in this matter. Were you authorized to compel the majority to return to Councilor Kofa's gavel? Did the court say that?
I am saying, and have just said that we.
Yes or no? The court said that?
It had not been determined by the court.
Oh, okay.
What have only been determined by the Supreme Court is a petition to determine the constitutionality or the unconstitutionality of certain actions of some members of the House of Representatives. That is the only one the Supreme Court had touched on. There is another petition that I filed on behalf of Kofa that is specifically about the illegal removal that is yet to be charged or for a citation to be issued out by the court on the parties. There is another madamus filed by me also.
How many madamus?
Along with Councilor Pierre.
How many madamus? How many madamus proceedings?
We have found the madamus, but it had not been assigned by the justice in Chambers.
How many you filed? Don't mislead the public. How
We
many?
found the one Madamus. No. Kofan had 2 lawyers. One, the first set of lawyers were Councillor Justice Kabina Jane and Stephens. They filed the first paper. I think it was a prohibition. But we have filed only one Madamus. Now you have been the sign. But let me just rest on this particular second issue that the Supreme Court made in this ruling, which is the cross of the debate. The Supreme Court said any setting by members of the House of Representatives, because the constitution was, what we specifically asked the Supreme Court was to declare the setting of the members of the House of Representatives as illegal and unconstitutional, in violation of Article 33 and Article 49, as well as their rules. So when the Supreme Court ruled today that any setting by members of the House of Representatives that is inconsistent with Articles 33 and 49 of the Constitution is considered ultra-virus. And for people to say that it's not clear, I respectfully disagree. Why? Especially a lawyer.
Councillor Johnson, that is not a dispute.
Let me get there, Council.
No. You're trying to mislead the public. That is not the dispute. What did the court say?
Let me get there.
The court said that it should return.
I just want also to analyze this Article 33 and Article 49. Article 33 says, this is what the court said, that the House of Representatives shall have a quorum, I'm just paraphrasing now, shall have a quorum to conduct regular business of the legislature, specifically House of Representatives. And a minority that fails to form a quorum shall not sit from time to time until they will compare others who are absent to come to section. Correct. In order to get the quorum.
Correct.
That's under normal condition where the presiding officer who shall be the constitutionally designated person.
And so
defined by the Constitution. Either the speaker or the deputy speaker in the absence of the speaker when the speaker is incapacitated or is outside the bailiwick of the republic.
Councillor, did the court say that the majority having sat in a position that is ultra-virus, did the court say that it could compel the majority to return to Councillor Kofa's?
That was not a Madamas.
Councillor, the court said
interpretation.
You misleading the public. The court said very clearly that it has no authority.
I think we're having some issue here.
The court said it has no authority to compel the majority to return to the Garguah. Councillor Johnson, come on, don't do that. Councillor Johnson, come on, don't do that. The court said there is no law to compel them.
Councillor, we can't proceed like that. An irrepetition does not it declares what the law is. That is a repetition.
So they return to where they were, right?
Madamus is the one that the court will compare you to perform.
You are talking all over the place. The question to you, you're talking all over the place. The question to you, did the court say there exists a law to compel the majority to return to the Garguah Council?
That is Madamus.
I'm not asking what the Madamus. I said, did the court say that? The court said there exists no law. In its judgment, it says there is no law. Don't say no.
But Councillor, let Arthur rest and then we can all tune in, right? Let Arthur rest and we can all tune in later on.
Arthur is all over the place. It's misleading the public by being all over the place.
Council, what the court said was the minority should compare the absent members to perform, to come to section. And that the legislature should have passed a law that will fill that gap as an extension of Article 33. But there is no law showing the procedure to compare their colleagues to come to section.
So then what happened?
That is what the court said.
So then what happened?
Council, we don't do that. There's not a...
Councillor I will not sit here and allow you to mislead.
People want to listen to us and hear what we're saying.
No. I will not sit here and allow you to mislead the public. You are reading the court.
The way you understand it. Time with the choice of words. your choice of words should be very respectful. I think that is why I'm trying to.
If you are misleading you are misleading. I'm not insulting you. I said you are misleading the public.
I'm just telling you.
So I just hold it 1 minute. Let me ask one question. What is misleading that he has said?
Attorney Jackson, the court said in simple English, the majority where you are sitting is in violation of the law.
Do you want to encourage them to continue to sit in that place?
No, wait. Hold on. I need to continue. I don't stop the way you guys can stop. The court said the majority where you are sitting in simple English is in violation of the law.
Right.
The court went further to say that, however, there exists no law that will allow us, meaning the Supreme Court, to compel the majority to return to status quo ante, return to where Council of Phonetic
No. You are now misleading. Council, you are now misleading.
The law, the Supreme Court said there is no law to compel the majority.
Council, you are misleading because they can't. I think after we finish, then I'll correct you. But I think you are misleading. Then after go ahead.
This is what I'm saying. The court said you have no laws that will show how to
compel. That statement was in the statement of compulsion.
Therefore, we cannot compel. That's what the Supreme Court said.
There is a law already that says you must compare.
Where's the law?
You compare them to come to section. You did not pass the laws.
Councilor Johnson, there is no law. It is this type of representation that you take before the Supreme Court that may lead your client, that makes you a victim. Because at the end of the day, Councilor Kufa will be removed as Speaker.
It doesn't matter. Let me say something here quickly.
The Supreme Court had just said that, look, we do not have authority to compel. That's what the Supreme Court said in his opinion. Is that a clear opinion?
Yeah, Councilor Jerry, I know you go ahead to discuss. Let me just lay. I am not interested in the mentor about this to be opinionative and say all kind of things about other parties or the parties in the case. I'm just trying to provide what I know, what I saw, what I have.
You are all over the place. You are all over the place.
The Article 49 that the Supreme Court was talking about under the Constitution was about it says that the Speaker, and in paraphrasing, the Speaker and the Deputy Speaker are elected for the period of 6 years. And that they shall be removed from their positions for cause. For cause. And so they said, any sitting by the House of Representatives that is inconsistent with these articles, Article 33 that I just explained, and Article 49 that I've just talked about, when you're sitting consistent with them, then your action is octroi virus. In the meaning of these interpretations by the Supreme Court, and my understanding as a lawyer, it means that the majority black sitting over the period, because they are in majority, now reaching the adequate number of 49 resolution to remove the Speaker is unconstitutional. And you cannot remove the Speaker without cause. And you and I know that cause, under constitutional law, in fact, in due process, cause is due process. To establish cause, you must have due process. And due process is a condition precedent for the removal of the Speaker. You can conduct an investigation. You can get evidence that show the guilt of the particular person that is investigated. If you can't obtain the number 49, then you don't have a resolution for removal. So the removal.
So the court said that?
For 49 is a condition subsequent of due process. So when the Supreme Court said you're sitting when it is in conflict with Article 33 and 49, then it means your sitting is unconstitutional. In my mind, it means it means that the actions of the majority black, their actions are unconstitutional. So no one can say that the Supreme Court was not clear. Only non-lawyers can tell us that the Supreme Court was not clear. So you can go ahead now, Councillor J.
So Councillor Johnson, there is no dispute as to what the court said where the majority of black was sitting. The court said that their action was ultra-virus. They were acting outside of the law. That is of no dispute. That is of no dispute.
It's what.
But
hold on. A court will proceed by saying that, having said that, the court will proceed and say that there exists no. Can I speak?
Councillor Jackson, let him.
You say that the court should have said this way.
Can I speak? Councillor
Contemptuous.
You have been shifted. That is contemptuous.
You mean shifted for what?
Contemptuous to question the wisdom of the court, the Supreme Court. You are a council at law.
So
the wisdom of the court and say the court should have said this way because this is how I feel, because I have 32 years of experience in the practice of law, council of law.
You're joking.
The Supreme Court, your action is
the Supreme Court did not make a ruling that favor your client. The Supreme Court was to go further to say that the majority, having sat in a position that ultra-virus, being the respondent, they must return to the authority of the speaker. Having recognized it, hold on. Having recognized the speaker, Article 49, the court should have also instructed the respondent to return to normalcy. The court never did that. You will see.
As a 32 years lawyer, for you as a 32 years lawyer, senior lawyer, and member of the Supreme Court bar, to question the wisdom of the Supreme Court.
Oh my goodness!
By the details of the statements you are making, it is contemptuous.
Councillor, you live in Liberia. People like you live in Liberia, so you are very fearful. I practiced for 32 years. When they look, listen. If I disagree with how the Supreme Court rule, you know what a rule called for. Within a period of 3 days, I'll file it for re-argument.
No, Councillor Gerard. Yes, Councillor Gerard.
What are you talking about? That I should say the Supreme Court rule in favor of your client?
No, you can say this is what we say, and you know that. You will say we accept the opinion and the decision.
No, I don't say that with you. You say that. I don't say that.
Let's say we disagree, but we respect the opinion of the court. That is what we say.
I don't say that because I will never speak the way you speak. The Supreme Court said there exists no law to compel the majority. What the court said in that by doing that, the court agrees that the majority can continue to say what it is.
In the ultra-viral position?
Yes. The court did not say there is no law that compares. The court said there is no law that show how to compare them to a thing.
Okay, so are they going to simple law that compares? Simple. Are they going to return to the Garguah or Councillor Kofa on Tuesday?
Pardon me?
On Tuesday, are they going to return to the chambers and participate in the deliberation? Councillor Kofa?
Political behavior, but if there are people who respect the rule of law, based on the decision of the court, in fact, when the court issued the writ and said everyone return to status quo ante, and every one of them still have never had sections, I think they're respecting the rule of law. And if every one of them had a sincere lawyer,
on Tuesday, listen,
disrespect the court.
On Tuesday, they will go ahead and sit in the same chamber with Councillor Kofa.
Pardon me?
On Tuesday, they will sit in the same chamber with Councillor Kofa.
They need to go back to Kofa and raise their issue. That's what the Supreme Court said. That is what the court said.
I think you do not understand what the Supreme Court said. I think you arguing sentiment. I think you do not understand what the Supreme Court said. I think you arguing sentiment. I think you do not understand what the court said. There is no law to compel the majority to return. Therefore, where you are is to wait on Tuesday. You will see what will happen. They will go back to the regular chambers.
No, Councillor. I am still correcting you here. The Supreme Court did not say there is no law that compels the majority black to go to section. The Supreme Court said there is
I'm not saying that.
That shows how to compare.
Right. How
Not
to compare.
How to compare. That is
don't be semantic. Don't be semantic.
But that's what the law says. That's what the letter is. The letter of the law is how.
Attorney Jackson,
how?
the Supreme Court said,
to compare them.
So let us not go into circle. I think we need to have a conversation flowing. Let us not go into circle. I want to thank Arthur for his intervention, which I think must have broadened the knowledge of our listening audience.
I just wanted to make this intervention. Councillor Jackson, Tomalin, thank you very much for inviting me. You guys can have a good time. Thank you. I
think, and with that, let me say a few things, then other people can join and shine. I think the explanation provided by Councillor Arthur Johnson has helped to broaden the knowledge of people who are earnest and willing to take the information provided by him. You know, while we are making effort to explain this matter in a sophisticatedly simple way, we will not be oblivious of the fact that there are people who will want to engage in grave propaganda. Grave propaganda is where my friend or colleague will come on the platform, pretend to be neutral, even though the member of the majority black family comfort in his argument. You don't need to tell me, say, you're neutral when the majority black men were leaving the phone and say, Councillor J. Were there. Y'all listen to him, Councillor J. Were there. There's something going on here.
What is going on?
Councillor J. Were, I am just saying, it's plain and simple. The law is commonsensical. If your colleague, if the people who are the majority bloc who share your opinion, who are comfortable with your opinion, if the law say the complete Supreme Court today said that the setting is ultra virus, are we going to gaslight this audience that people who sitting in an ultra viral place it's proper for them to stay there? To make that kind of argument is to gaslight the Republic, which I think is egregiously wrong. If I am sitting somewhere and the court is uncomfortable where I sit, and the court says where I sitting is ultra virus, you want me to continue to sit there? You want to argue around that to confuse the people, to gaslight the Republic? I think it's egregiously wrong. Let's tell the people in the majority that the court to say, okay, the court said the ultra virus, however, it ain't compared. When the court say you ultra virus, where you sitting is improper, you don't have the authority, you didn't go about it in the right way, and it's void ab initio. It just it goes with us saying go back to where you're supposed to be. That's what the court is effectively saying. Really? You sitting somewhere, the place is ultra viral. Do you want to continue there? The best thing to do is to go back to where you're coming from, which is what the court anticipates. And I believe anybody who wants to be respectful of the court's opinion will go back to where they used to be and don't stay in that place that the court had declared to be ultra virus.
When you practice law, you take away sentiment. You introduce what the proceedings are. And you ensure that a client is told. You know what we do? Is when you file a case before the court, you prepare something called legal memorandum outside of your sentiment. And you advise your client as to the position. You see, Johnson came here, what did he do? He began to tell you how many petitions he had before the Supreme Court. He's not telling you whether there is one, asking specifically, how many madamas do you have before the Supreme Court?
He said one. He said one. He said one.
What did the Supreme Court, what did the Supreme Court decide today?
He said it was an in-repetition determining the constitutionality of where the people said.
You can't speak for Councillor Jackson.
That's what he said. We all listen to the man. Stop gaslighting the Republic. Don't do this.
You can't speak for him. This is not a political talk. This is
no, we listen to him. I'm a lawyer myself. Don't say not political talk. You talking politics now because you participating in a political conversation. We're not in court here, so you can't argue that there's not political talk. You bring in political sentiment. You are siding with the majority bloc that which action has been declared as ultra virus. So how you say there's not political talk? You try to find way to dance around a court opinion that declare your friend's position to be ultra viral. Is it not political talk?
Who's my friend?
The majority of blood have found comfort in your argument. They are your friends. If they were not your friend, they will not single you or say, yeah, JWell, listen to JWell. I know great propaganda. I know people who pretend to be neutral when they're really taking side.
Anthony Jackson, I don't represent them.
You don't represent it, but you share the opinion. You think that when they ultra viral, you stay in the ultra viral position.
Lawyers, I don't just represent people on the street.
Yeah, but because he shares the.
I sign if I
will represent say the people position ultra viral. And what are you trying to say?
If I will represent you, I will sign a written contract with you.
No, I'm saying the argument is not that you're representing them. The argument is that they are comfortable with your position.
But that doesn't mean that they are my friends.
What's that?
They are my friends. They are not my friends. I don't know anyone.
You want to disown them?
I'm not disowning them. I'm not their friends. I don't know any one of them. If anything, I know Councilor Barney Sherman better. I don't know any of the people who in the house. I'm only telling you the Supreme Court cannot sit and say that you are acting in a way that is ultra-virus and stop there.
No, the court stop there. So what are you going to do about it?
I don't represent them. If I were representing them, I could do one or two things. I don't represent them.
Now the court said they are ultra-virus and they stop there. So what are you going to do about it?
What am I going to do?
Yeah.
Yes. I don't represent them. So what would I do?
So stop gaslighting our people. Stop gaslighting our people. Stop gaslighting our people. The code is clear. Stop gaslighting the people. The code is clear. Their position is ultra-virus. Ultra-viral means they accept outside of the law. Therefore, they are wrong. That's what the code says.
I asked the leading counsel in the case. So what did the court say? Did the court say the majority should return to where Counsel Kufa is sitting in the chambers and conduct business consistent with law? He said no. He said the court has not decided. So you know, it's a different situation.
Here is my question. Here is my question to you, Mr. Counselor. Did the court say that the majority sitting, was it right or wrong in that ruling that you read?
I wouldn't repeat myself. I've said that I just said that the Supreme Court said that the majority in sitting their actions, if it fell outside of Article 30, hold on, I'm not talking public talk.
Okay.
If their action consistent with Article 33 was not consistent, and the sitting outside of the chambers, not under the presiding, which is the Speaker of the House, their action constitute acting in an ultra-virus manner.
Okay.
Now that's
so.
Hold on. Don't stop there.
So was that not in an affirmative?
Hold on. When the court said that, the court said that even though Article 33 says that the minority must compel the majority or the absence representative from time to time to appear, the manner in which to have them to appear, this court has no authority to compel them.
Yeah, but we're going to be, I think you're moving the goalposts. But the Supreme Court.
Robert, have you read the opinion? Robert, have you read the opinion?
But you yourself have not read the opinion. Stop asking the that kind of question.
Because as a lawyer, I think
I run a law office in Liberia.
Okay, so what
stop what you're doing and you're trying to brag. You know, forget about when you run, when you don't run. Barney Sherman, Councilor Barney Sherman. Listen, you will come in. Let me just say this quickly. Let's stop this bragging. Let's be professional. Because Councilor Barney Sherman, and I said here earlier, that Councilor Barney Sherman, who argued against Councilor Arthur Johnson, taught both Arthur and myself. But it did not mean that Barney Sherman made the best argument in court. That you wait, let me lay my thought, please. Let me lay my thought. I don't want the conversation to degenerate into this comical chest beating about, I run a law firm, I do this. Beside it, what we want to listen to, is a sound legal argument, which you are failing to do for the public. What I would say, look, listen, let me say this for commonsensical purposes. I've been around the government. I spoke for government before, and I know when government try to spin things. In the instant case, and I'm taking common sense to a higher level, because this case is a political case. In the instant case, when you see people who are government supporters say that the court did not rule in anybody's favor, it is a tacit admission that they lost, and they're trying to console themselves. This is clear and simple. People who support government, people who are in for the removal of COFA, when you hear them argue the way the guy is arguing that, oh, the court was neutral, the court did not rule in anybody's favor, they are admitting tactically that indeed the court passed judgment in favor of COFA. If had the court ruled in their favor, they will not say the court was neutral or the court decided to not be very clear. The court is clear as per our opinion, our reasoning, or what we all read. Almost everybody here went to college. All right? I hold a master's degree. Lofa went to college. My friend Robert went to college. The audience, people in the audience, they are intelligent people. When the court say your setting is ultra-virus, it's a Latin phrase that means you are conducting yourself in a manner not supported by law. You are acting outside your authority. It's clear and simple. There is no two ways about it. And let us not gaslight our people.
Okay, let him speak now, please.
Let's get his counter statement.
I'm laughing because I said Jackson, it just went all over the place. That's a simple thing the Supreme Court should have done. The court went very fairly to say that. And I agree that the majority is sitting where they are sitting violates the law. But the court did not stop there. The court said, however, a law to define how to compel the majority to return to normalcy doesn't exist. Now, when the court says that, I agree. I said Jackson, I agree because you have had little or no experience in how practice goes on. How laws are practiced. I'm sure you have little no experience. Because if you have experience, you will see the court will have to end by saying, this case, the defendant is hereby evicted. I just mentioned it, an ejectment suit. You don't file a lawsuit and the court comes and says you are occupying the premises illegally. And don't say anything else.
Let me push back on what he just said, right? Let me just push back on what he just said in just 2 sentences. Let me just push back on what he just said, you know.
Let him land.
Okay, let him land.
So wait. The court will have done justice today by ruling in favor of Councillor Kufa and instructed the majority to return to the speakership of Councillor Kufa. If the majority had left, that would have left no room for the majority to interpret to say, look, the Supreme Court did not say that we should return. In fact, the court said that there exists no law to compel us to return. Guess what will happen on Tuesday? Councillor Kufa will be tracked of whatever thing that he is having. It doesn't mean I know all of the justices, as I said, on that bench. So, and I know what he can do better.
Let me push back, Robert. You're coming. Let me just push back on what he just said. Because let me say this. I'm trying my best. I'm trying to restrain myself. I want to be deferential to our colleague. And I hope he will do likewise. When Councillor Arthur Johnson was speaking, Councillor Arthur Johnson reinforced everything that I have said. In fact, Councillor Arthur Johnson even tried to now accuse you for being contemptuous of the court, the way you were sounding. So forget about he ain't practice law, so he ain't do this. Those things are improper to say. You are repeating yourself on the show. You keep saying one thing over and again. Councillor Arthur Johnson even corrected you. You still do not want to take the correction. The correction Arthur provided which you consider to be semantics, I think it's wrong, because even in the law, the court will take into consideration to explain simple words. What the law say is that
anyway,
we don't how the question the court was dealing with. Arthur reminded you. You keep saying that there is no law to compel. Arthur said no. They didn't say there is no law. They say there is no law telling us how to compel you. There is a law that says we should compel you to come to court, but how? You said it was cemented because you don't have a counter argument. You keep repeating the same thing. Stop gaslighting the people. The court is very clear. The court was clear. You can't come and say, this is how the court is supposed to write. This is how the other things supposed to do. No, you're not above the court. Trying to say, oh, because you don't practice it here, so this is what the court will do. Stop it. The court was clear. I think in the court's opinion, this is clear. It's for reasonable people to supply meaning. I'm talking, and you gotta be calm too. Now, when you were talking, they asked me to listen to you. No, they're not all over the place. Because you're repeating yourself, that's why we're all over the place. I think you would do well not to repeat yourself as you've been doing. I just corrected you that the issue in the law is how to carry on the compulsion. How do we compel? Is that there is no law to compel you? How we will do it is the question. And those simple things are always painstakingly considered by the code. So don't gloss over it. The other thing here is, and you're being disingenuous. And I would say this with utmost respectfully. You've been disingenuous. You're sitting somewhere. You don't have to be any sophisticated lawyer to practice 100 years to understand that you're sitting in a place and the court said that place you're sitting is ultra-viral. You want to tell the Republic, you want to tell our listening audience that you got to sit in that ultra-viral place continuously, or you will readjust, or you will do the proper thing.
You know what a court decision look like. So if you know, you wouldn't say what you are saying.
Okay.
Oh, you know it. I just say you're wrong and you're misleading everybody and you've been disingenuous and dishonest with the conversation.
You know who Arthur is? Arthur is my student.
But Councillor Vanisham thought Arthur, which I admitted to.
I just said
Arthur argue against Arthur Johnson. Councillor Shemo. So what's the point?
Arthur will tell you that.
What is the point? Councillor Vanisham taught me today. Arthur argue against him successfully. So what's the point you're making? It's a meaningless point.
Until you go to sit and practice law, you are confused.
Okay, can I ask a question? Can I come in for a second? So
go ahead, I think you're being disingeneous. I think you're trying to be dishonest. I think you're trying to mislead the people. That's what you're doing.
So going for let's get Robert's question.
After practice law, he just challenged you here.
Okay, guys, let's do this, right? Let's get other views on here. So hopefully we can get your position. And parting, unfortunately, due to time constraint, we got to go. But Robert, what's your question? Is it for Anthony Jackson?
Here is my question. It's not to Isaac Jackson, because Isaac Jackson has not confused me.
Okay.
I think Councillor.
I was confused.
Yeah, I'm confused because when you as a lawyer who has this immense experience, and it bothers me because we have a president with 43 years of experience in public service.
Oh, ask a question.
Well, no, 1 second. I will ask the question.
He messing the country up.
We see exactly what's happening, right? He's moving around the country like chicken with our head, right? Lack of leadership all over the place.
What else
happened? When you mention this experience, you confuse me and everyone else because we don't understand. So let me read Article 33 and 49. Then I will ask you this question, because Article 33 and 49 were specifically mentioned in the court's ruling today. Here is what Article 33 says: a simple majority of each house shall constitute a quorum for the transaction business, but a lower number may adjourn from day to day and compel the attendance of absent members. Whenever the House of Representatives and the Senate shall meet in joint session, the presiding officer of the House of Representatives shall preside. So I want you to think about this. Who is the presiding officer of the House of Representatives? I want you to ponder that question. Here is what 1 second. Here is what Article 49 says. Article 49 says the House of Representatives shall elect once every 6 years a speaker who shall be the presiding officer of that body. a deputy speaker, and such other of officers as shall ensure the proper functioning of the House. The Speaker, the Deputy Speaker, and other officers so elected may be removed from office for cause by resolution of a 2/3 majority of the members of the House. Now, the court in its ruling, I don't want you to confuse everything else you're talking about. Please don't even mention it. I just want you to focus on this line.
How did you read it?
1 second. That this court interpretation of Article 33 of the Constitution of Liberia, 1986, is that whether a simple majority is sitting or a lower number, in both cases, a presiding officer defined in Article 49 of the Constitution is the Speaker, and in his or her absence, the Deputy Speaker shall preside. Wherefore, and in view of the foregoing, any sittings or action by members of the legislature not in conformity with the intent of Article 33 and 49 of the Constitution are ultra-virus. Here's my question to you. I don't want you to tell me about where the Supreme Court did not stop.
Did you understand what you read?
Yeah, sure.
You've been disrespectful to the man now. Why are you asking that kind of question?
I honestly know that's okay. It's okay.
Anthony Jackson, Anthony Jackson, let us not muddy the water.
But the question is disrespectful. Why is it that you understand what you read?
Let him land and it will respond.
Yeah, it's okay. I didn't understand what I read. It's okay. But here is my question to you. One question is, who is currently the Speaker of the House of Representatives?
You want me to answer?
The question was posed to you.
Are you big? Come on, man. Who is currently the Speaker of the House of Representatives?
Is that in dispute?
I'm asking you if it's not in dispute, then say it.
For the sake of our listening audience,
wait. No, if it's not in dispute, I want you to say on public radio, who is the Speaker of the House of Representatives currently?
You know what? I asked whether you're honest to what you read.
No. Can you answer the first question? Who is the Speaker of the House of Representatives?
I have to talk.
Robert, give me the chance to land. Let him respond to your question. Go ahead.
I asked the question whether you honest to what you read from 33, 49 for a specific reason. The reason is 33, 49, recognizing the presiding officer as a speaker is not a dispute. I have not said that the presiding officer is not a speaker. I never said that.
So who is the speaker?
Hold on. Do you want my answer or you want to argue with me?
I want your answer, but we don't have time. So I just want you to answer this.
Who determines the time? That's why I said when you read, you confuse yourself when you read plenty and you don't understand.
No, I'm not confused. I just want you to answer the question. I have no questions.
So Article 49 designates the presiding officer to be the speaker. Up to this point, Councillor Funati Kofa, as per Article 49, is not a dispute that he's the speaker.
Okay.
It's not.
So great.
Hold on. You see, that's why I say.
I will give you the time to speak, but I just want you to ask the last question.
No. You can't
I want to ask the last question so you can speak.
No. You asked for 33 and 49.
No. The reason why I read that, in addition to what the coach said, yes, the reason why I read that.
Let him land with his response. He did not conclude. Let him land with his response, and then you can counter it. Go ahead.
If 49 of the Constitution, Article 49, refers to the presiding officer as the speaker, which they could refer to, that's not a dispute. Article 33, talking about simple majority and who presides, is not a dispute. When the court says that, the court needs, my contention is that the court needs to go further. In practice law, the court will rule and say the defendant. I gave a very simple example in an injectment suit. The court will rule and say Councillor Jallah is occupying this premises in violation of law, so the ejectment suit is upheld. The court doesn't stop there. The court will say Councillor Jallah is order evicted. Today, all the Supreme Court says, said that the sitting of the majority is ultra-virus. Right.
So, Councilor Joe, I'm sorry. Can I just pose a quick question for clarity here for those of us who are not legal practitioners, right?
Okay.
You both points you said are not in dispute. What is it then that we need clarity on? Are you also claiming that okay?
Your question is
I'll end at that point then. Go ahead.
Your question is pretty much to the point. Sitting down outside the law, who the speaker is, the interpretation of Article 33, 49, those are non-dispute at all.
Okay.
The Supreme Court, my contention, which my friend Jackson said, oh, those people, they are your friends, which is funny to me, because my contention is courts do not rule that way. The court will identify the problem and say, again, simple thing like my ejectment suit, the court will say that your occupation of these premises is in violation of the rights of the property owner. Take where my office is. The court will say, Councilor Jewa is occupying this, his law office is occupying this office as in violation of the rights of the owner.
So are you saying because...
No, wait. The court wouldn't stop there. The court will go forward and say, because Councilor Jewa occupation of this premises is in violation of the law, Councilor Jewa is hereby ordered evicted.
Okay, so can we?
No, guys. Let me
answer my question. Ben, please. I'm sorry to interrupt.
I like what Lofa.
Ben, I'm sorry.
So then,
attorney, you haven't answered my question. You haven't answered my question.
Hold on 1 second. Let him close up on it, and then you
So in this case, that's what the Supreme Court did. The Supreme Court said the sitting of the majority is in violation of the Constitution. After the court said that, because mind you, the majority did not go before the court with anything. They didn't ask the court for anything. It is Councilor Funati Kofa who asked through a mandamus proceeding and in re-proceeding. So after the court said that you are all sitting down in the wrong place, in the wrong place, the way you sit down. The court should have gone further to say, being a respondent, return to the authority that the law provides. The authority that the law provides for is the speaker. The person who has the authority to call to ensure that the absent member return to session is the speaker. If you don't say that, you are giving the party ammunition to interpret any way they wish to interpret.
Okay, so Councilor Jarrett, go ahead,
common sense. This is where common sense comes in place.
This is not common sense. This is law.
But listen, no, common sense.
The law is commonsensical.
Come on,
the law is commonsensical.
Can I say my piece without being interrupted? Then
go ahead, bro.
You just said something very profound as a lawyer, right? Okay. If you concur that the court says the majority black, right, sitting is not in conformity to the law and the Constitution, right? What further step is required for you, not only as a legal mind, but as a law-abiding citizen, to say the court has said where I am? I will list the Constitution, and I must return to the main chamber. Do you also want the court to say return before you return?
Let me give another second.
No, here's my question to you. Okay, what's your question to you? Here's my question to you, sir. Then I will stop because I'm quite friendly. I'm exhausted.
I like to listen to you, Robert.
I'm exhausted by this because you know why I'm exhausted.
It's
annoying me because I feel like
because you reading plenty that you don't understand.
I think this has been done intentionally, not the first time, the second time. Because everything you just said, you agree with the Supreme Court. If the Supreme Court says where these guys are sitting is in violation of the Constitution, and the conduction of their business have violated the Constitution and the rules put forth by the House of Representatives, that the Speaker have not been absent. The Speaker has shown up to work.
So what's your question?
Because the Supreme Court ruling also said, in the absence of the Speaker, the deputy
so what's your question?
The Speaker have not been absent. So if you agree that the Supreme Court says where you guys are violates the Constitution, in your own mind, if you was a lawmaker, would you sit continue
I'm
to
not a
sit
lawmaker.
in no, what you tell you okay, you're not a lawmaker, you're a lawyer. Would you continue
wish
to
to be
sit
one.
in a place that violates the Constitution because you said the Supreme Court did not authorize you or instruct you to return to where you're supposed to return?
Robert, let him respond so Mr. Anthony Jackson can
Come in. Okay, thank you very much.
I'll let for Anthony Jackson to counter his response. Go ahead.
Let me answer.
Hold on 1 second, Ben.
Let me
Go ahead, Councilor Jallah.
Let me answer a question with a decision, a recent decision of the court, of the Supreme Court.
Mm-hmm.
You know, in the case of Republic of Liberia versus Guar, Mususka, and others, in the court below, Justice Scott and her family members were all convicted for murder. I'm sure you guys follow that. They were sentenced to life. The lawyers representing Councillor Scott and others and her family people filed an appeal, contended that the evidence on which the judge ruled to convict Justice Scott and her family members, the evidence was not sufficient. It created doubts. And so what did the Supreme Court do? This Supreme Court that ruled today the way it ruled, the Supreme Court said that the state, the evidence produced by the state ran contrary to law, and that the evidence in itself being having created that amount of doubt, the court revised the conviction of the lower court. And the court didn't stay there. The court revised it and ordered Councillor Scott and her family people released.
That's orange and apples.
If the court has said, I'm talking about how the court ruled.
But that's orange and apple. The case you're making reference to is different from this.
Let me start in.
Let him land so let him land so Anthony Johnson can counter.
The entire country.
How do we get? Robert,
you will always be.
You're referencing a case that had nothing. It doesn't even matter.
No, Robert. My reference to that case is that if the court had ruled and say the conviction of Councillor Scott and her family members are hereby reversed and stopped there, the Councillor Scott and her family member who have still been in prison today.
No, Mr. Jallah, there are implied laws. There are certain things that are implied.
Oh my goodness.
There are a lot of laws that are implied.
Hey Ben, we're not talking about implication here. Ben.
No,
Ben,
I mean, it's implied.
Ben, I can see where you're coming from, but I'm saying to you, the court will make a definitive decision. The court, what did the court do? The court said that the trial in the court below was so fraught with errors that it revised the decision of the lower court and ordered Justice Scott and her family people released. Okay. This court said today that which I agree, that the majority are sitting in a spot that is considered ultra-virus.
Okay, Councillor Jallah, thank you. Let's get Anthony Jackson. Ben, hold on 1 second. Ben, please. Ben, please hold on 1 second.
Let him go ahead. Let him say what you want to say. Let him say what you want to say.
Go ahead.
Thank you, Mr. Councillor. Are there implied laws or there are not implied laws?
You know, I don't go to court to argue if they're implying law or no implying law. I go to court on the facts. I go to court on the law that support my client case.
Councillor Jallah,
let me call him, man. Let me.
Let's be honest here. Let's be honest.
Let me come in quickly.
Audience and educational purpose. Is there one?
No.
Can you speak to that? Is there one?
No.
Are there not implied laws?
No.
So wait. I mean, let me give you
Ben. Okay. Let's take Anthony Jackson. Jackson. He said there isn't one.
I said no.
Ben.
Let me look.
Anthony Jackson, go on.
Laws. I would name a lot of implied laws in America. when you take your
we're talking about two jurisdictions.
Oh, but
you know, let me come in quickly. Let me.
You cannot drink under the influence of alcohol, right?
Ben.
May I come? Ben, thank you. May I just come in now? May I come in now? You know, what we are observing on this platform tonight, I think it's pathetically ridiculous for Councillor to just continue in this circle, the same circle that he's been repeating himself in.
I'm sure if I argue on your side, you'll be fine. Councillor Jewa is
you know, I mean, it's you know, it is an established aphorism that people who do not retract their opinions, even though wrong, they love themselves more than they love the truth. The councillor here, the councillor has an opinion, a ready-made mind. He's being in a way dogmatic to that opinion. And for him, since the Supreme Court did not clearly say, you do this, then the Supreme Court is going to be wrong, or the people who they're doing what they don't know how to do. And I think that way Arthur Johnson said his statement was contemptuous. I'm happy that Robert even tried to tell him, say you're comparing apple and oranges. You bring a murder case and you want you gotta keep your calm now, please. Keep your calm. You gotta keep your calm. You bring a murder case and you take it fast from murder case and want to convince people about a political case happening in a political theater. This thing you're doing tonight, it will haunt you. You undermining yourself. It's not good to do what you're doing. If you were sitting somewhere and you putting us to keep repeating ourselves, and I'm finding it very sickening. If you are sitting somewhere and the court say where you sitting is ultra virus, will you remain in that position or will you change course? It's obvious. It is commonsensical. It is wide. It is needless to say go to your original place.
Because
it's plain and simple. It goes with us saying that you should return to where you used to be. You are sitting in the wrong place. You are going about things in the wrong way. Go back to where you belong. And that's why when I started this conversation, I drew an analogy to filing Davos petition.
And he thought
what?
He thought there was a match.
What's that? What I thought was a match. You just brought a murder case and try to take part from murder case and convince of a political case. I'm talking, my context here is if you are agreed, let the lawmakers are agreed with Kofa on account of their Trump or allegation against him, they can't just move to another room and say, oh, we have removed him. There are established procedure laid down in the law that they should follow. Similarly, if you are aggrieved by out of misconduct of your partner and you want to divorce that partner, you don't just wake up in the morning and go to your auntie or your uncle and say, look, I don't want that woman again and I leave her. No, you must go and file proper paper to the court and you must give why you file, what charges you got against her. In an instant case, we find people that are doing things that are just clumsy and making the country a laughing stock. You can't wake up one soon morning, go in one other room and say, oh, we don't want our speaker again. Then law, that's what the Constitutional Court did today. The Constitutional Court was drawing attention to what? Constitutional compliance. Follow the law. You sitting in the wrong place. Who asked you to go in that place you sitting? That's what the court saying. You come here and say, oh, the court supposed to explain it in the language I want to hear. And I think it's just ingenious. The court not supposed to please you, rather in my place. As long as you say the person in the wrong place, court, you must add another sentence, say, go back to where you used to be. Mama, what is this? Is overly simplistic to be coming from a lawyer of 27 years of practice. What is he doing? Why are you embarrassing us? You're embarrassing Liberia. Say, oh, is that a Liberian lawyer of reason? Is that a reason of a lawyer who practiced for 37 years?
Because you had never practiced law.
Who told you that?
All right. So
who told you that? I practice. Why are you telling you never practice law? You see how you're becoming arrogant for no reason? Because you're being called to order. You're being arrogant for no reason. What do you mean you have never practiced law?
Jackson, you never practiced law.
No, you don't say the truth. You don't know me. You are now proceeding on the basis of the regular knockabout political garbage. I practiced in Liberia before I left.
You admitted that you had never practiced law.
Did I say that?
You had never practiced law.
I think you've been very dishonest. I've never told you that. I said I'm not in active practice. They didn't mean that. I've never practiced law.
Before you say active? Were you in it before you say active?
Okay,
I mean America. You think I was going to be practicing law in Liberia while I stayed in America? That what you think? I left Liberia almost about 10 years ago. You really think I was only practicing Liberia when I left Liberia 10 years ago? I spent 5 years in London and I'm in America now. You think I was only practicing law in Liberia? And you want me to come here and lie and be dishonest like you trying to do tonight? I left Liberia to represent Liberia to represent Liberia in London, where I stayed 5 years. I was not practicing there. You want me to come on the show and say, "Oh, I'm practicing law in Liberia"? I will not be dishonest like you. You are sympathetic with the lawmakers who are in the majority bloc. You don't want to be earnest to spread on this record that you are sympathetic to them.
And they are my friends.
You should just be able to say that. Let's say I'm sympathetic to the people who violating the law, that the court has declared their position to be ultra-virus. Be honest to say it.
Mr. Jackson, let's do the Anthony Jackson and Councilor Jerry. Let's give our audience the opportunity to contribute to tonight's conversation. We'll start taking calls from back home first in Liberia. So guys,
let me speak now, Lofa. I haven't spoken yet. So this is what I wanted to ask the dear counselor.
Yeah,
you know, the reason why I said about implied laws. So I don't know if you were joking when you said they aren't ending. So I wanted to give the benefit of the doubt again to clarify that, because I'm sure you were joking. Are there not implied laws anywhere in law? Anywhere in laws?
Maybe.
Okay, maybe. You war against us, no, maybe. What are you doing?
I'm making fun out of you.
Yes.
That's interesting, man.
And here's what I say. So when you go to the restaurant and you set an order of food, that's a contract you are signing with you and that restaurant. It's a legal binding contract. You think that people will say, because we didn't sign contract, you can just walk away and then go. It is implied.
What does it have to do with the Kofa case?
I'm coming. It is implied.
What does it have to do with the Kofa case?
It is. I'm coming. I was just laying because the first thing I was trying.
I know you more than you know yourself.
So
you believe that? Jackson, I know you. I said Jackson. I know you more than you know yourself.
Yeah. So what I'm trying to say here is that there are implied laws. There are things that are implied that don't have to be stated. When you went to the restaurant and you sat down, you ate.
There are custom, there are tradition. I just make it for everything. There are traditions.
Right.
All of those.
That same thing
implied in
law. So in law, if you owe someone rent, if your law office owes someone rent, and you went to the and somebody took you to court, and the court said that and the court said that you should pay, your arrears to that person. What the court is actually telling you in essence is that you are wrong, you are owing this person, and you need to pay them. They don't necessarily have to say it. And it's implied.
1 minute, let me attend to something. I come in 1 minute. 1 minute, let me attend to something.
When you say you're wrong, you're supposed to pay.
Yes, Ben.
When you're wrong, you're supposed to pay.
Ben.
Yes.
You know, when the court tell you to do something, the court will be definitive. Between you and me, wait, let me talk. Between you and me, our Supreme Court today were more political than legal. I said Jackson will say it's contempt. I would have not made a decision that would be leaving the public to interpret the way they wish to interpret. The Supreme Court very rare when it said these guys are doing wrong. They're sitting down here. Then the court must order them to return. If you don't do that, you create a room where people from the majority will argue and say, oh, the court is on our side. I have many arguments like that today.
So if your wife were to tell you, if your wife said to you, so if your wife said to you, counselor, there's a woman that you're talking to, you represented her. That woman that you're talking to, I found evidence that you are involved with her in extramarital affairs. Okay, but because she didn't tell you to stop. As a grown man, 32 years of experience, you will continue to see that woman in extramarital affair, waiting for your wife to say, stop.
So I guess my question to you, Robert, how does it apply to the Kofa case?
It applies because you agree that the court says you are sitting. Your sittings and your actions are in violation of Article 33 and 49. You agree. But your point is the court should have gone a step further. Forget the fact. Let's focus on where the court stopped.
Correct.
We agreed that, and in this case, all of this argument that the Supreme Court did not rule in anyone's favor, it's clear yet that Kofa got the edge in this ruling. Because every action that they've taken is not in conformity to the law in the Constitution. And so you agree, but don't ask me how, because you already agreed to that. Your contention is because the court did not instruct them to return, so the court have erred here, right?
All I'm saying to you,
that's insane. It's absurd that the court should tell grown men and women that should be an exemplar of the law. They are lawmakers. They make law.
So, Robert, why are you calling them grown men and women?
We are where we are right now because these guys have refused to do the simple thing. They have refused to give due process. Had they been in the main chambers, put on the floor,
you know what they would say to you? They would say
due process would not be here right now. But the court said you are wrong. You are sitting in the wrong place. Why must the court tell you to return before you return?
So because that's how the court rules. That's how the court will state. The court will make a clear decision. The court will make a clear decision. I'm saying to you, when you there's something called dictum. When you rule and say every other thing and you don't say wherefore and in view of the foregoing, the defendants are hereby considered guilty, or the defendants are hereby considered evicted, you leave the matter in abeyance.
Yeah, because 66 of the Constitution, lawyer, gives the Supreme Court certain authority to interpret laws. Especially when you have an issue where you have three separate branches of government. Okay, they were very clear today on the authority given to them as the Supreme Court to interpret the law in a particular case. However, the Constitution and the rules of the legislature does not give them or does not clearly define the process on compelling these guys to return, which is why they could not get that opinion. But I don't need that opinion. I don't need that further opinion from the Supreme Court to reach a conclusion here that they made the opinion very clear that where we are as lawmakers, it's illegal. It's unconstitutional. And so in order for us to get back and conduct that, we have to the chambers and show due process. Waiting for the Supreme Court to come in, go back before I go back. You're smart. You're a smart kid. Are you a child? Must they tell you everything? If you tell your son, that sneakers do not belong there. If you tell your son, the sneakers you pull over there at that door don't belong there. Oh, your son must wait for you to say, son, take that sneaker. Yes.
So, Robert,
give me a headache because you are a lawyer of 32 years. You should have all your experience, and you should be able to give your opinion on these cases legally. But you come there and say, "Oh, the Supreme Court they didn't say this, so they don't have to do it." But the Supreme Court said you said in the wrong place, so you will say in the wrong place and die there. You will work with the Supreme Court said leave that area or else you will die. You will stay there and die.
You will live when you Hey,
Mr. Jimmy.
Wait, let me ask you a question. Wait. Let me ask you a question.
Very short. No, I don't want to forget. Beg you, please.
Wait. Let me ask you, man.
It's very short.
Where's my friend Alio?
And I forget.
I don't know. I don't know who your friend is. We got Aliyu. I don't know your friend. Aliyu.
You don't know Ali Jackson?
You want me to answer the question? I can answer the question. Let
me speak quick. You know, since I am a nurse, we also follow laws. If I met an unconscious patient, all right, do you think I'll wait for them to sign a contract before I go to rescue them? No, it says I won't rescue them first, and still the law will still back me. In this case, no, I'm coming.
Really?
Bring it down. Let me bring it to the same thing that that Robert was telling you. If you told your son you're supposed to go to bed at 9 o'clock, and you come at 10:30, your son is still up. Did your son break your rules? Of course, you know he did. When you tell him, now listen. When you ask the son, what are you doing out here at 10:30? Must you tell him that you need to be in bed? You don't have to. It's implied that is.
So the son and the Supreme Court are the same thing?
Yes.
If I may come in, you know.
I enjoy you guys though.
Yes. Let me say this. He asked me for somebody who I don't really know, but let me say this.
You don't know Ali Jackson?
Who's that?
You don't know your brother Ali Jackson?
Oh, you just call it one first name. Now you call it Aliyu fourth name. I don't know.
Man, that's why I'm telling you. I said, I know.
He said, the first question was, do you know Aliyu? I mean, who's Aliyu you talking about? Now you say Aliyu Jackson. You know, I mean. But let me say this to our colleague here. What he's doing tonight is not fair to himself. What councillor doing to himself tonight is not just fair. What he's doing is bad. We all have you guys have given simple example, and maybe we supply another simple example. If he were to tell his son, say, no, let's supply more simple example for people who listen to follow it. Because alone you have decided not to concede your ground. So you will repeat yourself until the whole show ends. But let somebody give you a simple example. Okay. If your son was sitting somewhere and you told him that place you're sitting not good, do you really have to tell him, say, move from there? I mean, I'm going way to Liberian place now. Let's go to Wallace. Remember that place is not correct. Yeah. You know, you sort of tell me that place not correct, move from there before I move. Is that you trying to make Liberian lawyer to look like on this radio? Is that the reasoning here? The court said, where you studying not good. You said the court will say, move from there because the place not good. What is this that we're doing tonight? Stop gaslighting the Republic. The code was clear. Those people where they're sitting, their action is ultra virus. It goes with us saying that they should go in the chamber, in the plenary, and do the proper thing by removing the speaker in manner provided for in the law. So every other thing they've been doing over there, the code says what? Is void ab initio. For me, that is the understanding. For respected lawyer, that's the understanding. After King here and made that position very clear, Councillor Vani Sherman is properly advising his people to do the right thing. We want to move speaker. There are established practice and precedent, but we have removed speaker. Let's follow it. Let's not encourage the country to slide in the area where we will not respect our laws. I have said repeatedly that the law is just a paper. Until and unless we decide to get wedded to this paper, until we get married to our law and respect it, it will be nothing. And I don't think we should be in a place where we encourage people to flagrantly violate the law. Those who claim to be lawyers. Arguing now, my man, you're not practicing in Liberia, you're not do that. For me, it matters little. Practice in Liberia, jurisprudence that the United States are routinely condemned to be corrupt. It will be a thing even on me. So it's not a badge that I'm supposed to wear. You know what I mean? The United States State Department have routinely condemned that thing we're doing over there. And then when you come on radio, you won't celebrate it. Let's take our time. I've just said to you tonight, and all the reasonable people telling you tonight, you got to retract, you got to recant your position. If you don't recant your position, then you mean you love yourself more than the truth and the ruling that the Supreme Court issue.
So Robert, be my witness, I agree with Ansu Jackson. Is that okay?
Look at it. It's trying to be comical now. Ain't here? Ain't here?
You just said I should retract my position, so I will retract it and agree with you. Is that okay?
Absolutely. You might use the truth. Thank you very much.
I'm laughing because there are some people who said to me that you did not. Why didn't you support Cummings? So I said to them, look, I didn't support Cummings. I didn't support Joseph Walker. I didn't support any of these guys. And then the person said to me, oh, you didn't support Cummings because you want to be on the other side. Don't I have the right to say this is my position?
Well, it's your right, we respect it, but it's just wrong.
So my position consistent with law is what I just told you. I said Jackson can say you disagree, that's fine. But I'm saying to you practically, on Tuesday next week, Councillor Funati Kofa, which I believe was hunting, he did not even know what you're filing before the Supreme Court. You will find that they will take away his vehicle. You will find that they will remove him from the office.
Thank you.
And that will happen. Huh?
So let me ask you this question. Thank you very much, you brought that in.
I got to vote. It's going to be 6.
Yeah. I'm coming because this is not the first time you made mention about Flanty being ousted by those guys. I want you to address this. Do you think what they are doing to Flanty is illegal?
I'm not fanatic lover.
No, I know, because the last time you stated and said, "Oh, just watch it. He will be removed. He will be removed," because all of the things that all of the people who have said that Flanty will be removed, they have always stated these bad precedents that were set in the past. So, as a learned counselor now, I'm asking you, for everything that has happened and your own wisdom, do you think if that happened, would that be justice done to Flanty?
I don't address suppositions.
Oh,
but then have any way to address supposition.
But then why do you make mention that he will be removed? So why do you continue to say he will be removed? Why do you then say that?
Because this is a political question. This is a question of politics and not law.
Oh, so those other guys can just decide to just be there and disrupt all of the sittings that will be going on until the entire government gets ousted, right? Because
let me tell you what happened.
Because if you say this is political, and I'm telling those guys now, and we those of us who are on the side of the law, we will also be prepared to tell other people once they can't listen to the court, don't listen to them.
Let me tell you. Yes. Do you trust anybody in the house? Do you trust anybody in the house?
I don't have to. I don't have to trust them,
including the very Kofa you're talking about. Do you trust that?
That's what this thing has nothing to do with.
I'm being political. Do you trust Kofa?
I don't trust Kofa, but I trust the office.
I'm mentioning that to say that. I'm saying that to say that.
No. But that's a red herring. I trust the office.
This is not about Kofa.
It's not about
yourself.
All I'm saying to you,
who are trying to
all
happening, does not necessarily support.
Wait, Councillor Kofa was on the radio when he said that he knows how the house operates. Councillor Kofa, he knows how the house operates.
And what does that mean?
Wait, let me finish. He is aware that they can embed money into the budget. He's aware that they can go after collecting the money. Who said that?
But that's a red herring. So why are you doing this to us?
I don't support any of the guys in there because I know they don't really have anything to do like that.
This thing has nothing to do with Mr. Kofa's crime. Wait for the next show when we are discussing Kofa crime and the legislative crime. Then we will talk about it. Now we are talking about the illegal removal of someone. It has nothing to do with Kofa.
Go to sleep. You'll be removed.
Oh no! See, as a legal president, for you to be.
Okay, I gotta go home. Let me go home.
It is troubling.
Okay, but thank you. I think it was good to, having you on the show. You know, yeah, I mean,
when you see Alio telling hello for me, say Councillor J.Y. say hello.
Okay, brother. Thank you.
You
mean Alio, my uncle Alio Jackson?
Alio Jackson.
I don't remember when last I saw him, but it's good that you know Alio, and you were into my regards. I haven't seen him for a very long time.
African Bible College together.
Oh, wonderful. But Mama, you come from a church's background, and you want to support Rome. You are a good Christian. You want to support Rome, Mama. Even God in the Bible fought injustice. Why you want to support injustice? They want to remove COVID. That's fair. Let's talk so, man.
I graduated before Alio. I went and got admitted in the Presbyterian Church as a pastor.
Imagine you supporting injustice.
Wait, man. I functioned in the Presbyterian Church for about 6 years.
You always do well at the end of the show, but the beginning can be too bad for you. You always do well at the end of the show. Always been rough.
No, that's how I know Alio. Alio is a very good friend.
Yeah, he's my uncle. Yeah, he's my uncle. Yeah, he's my uncle. Thank God you know him. Thank you.
I know him. I know his wife, Dr. Divine. I know a lot of. I know Alio very well.
Your family friend. I consider you now a family friend. Say you know my uncle. But that you are a reverend and you supporting injustice is what's shocking to me. Because God fought injustice.
I'm not my boy.
And you know what? I'm beginning to fear. Councilor, I'm beginning to fear that your 32 years of experience, because they tell you got your law degree in Liberia, and this is the 21st century.
I think that's go ahead.
So what happened?
My uncle friend, I won't be high on you again. I'll leave.
So I graduated from let me tell you why I graduated. I graduated in 1990.
Eh?
I graduated February 16, 1990.
At the war town.
No, February 16. Our class was the last class before.
No, but 1990 war.
No, but we graduated.
No, it didn't hit Monrovia. I mean, it might not have hit Monrovia, but every time we talk about Brentford, we talk about 1990 war.
My class is a class with Kabina Janet.
Okay, no, I mean, I'm not challenging your credentials. No, I'm not going to do that. I'm just trying to say.
What I'm saying, what I feel now.
But now it makes sense now.
They call
now it makes sense.
Huh? What's that?
Now I said it makes sense. You know, when the country was going through all of these trying times and you be practicing, maybe there were a lot of things that you guys didn't learn, learning all around them.
No, we're before walking to Monrovia.
No, they were two people walking. It started from where Butu was. So before it created Monrovia, you were out.
But you have to practice though. You have to practice after the classroom. You have at least extra 2 years to practice.
Ben, when you go to Liberia, wait, let me tell you something. When you go to Liberia, go to the court and just say, "Do you know Councillor Joy?"
But all of you guys are all the same people, so they didn't mean anything different. They just that way.
I say
I gotta go.
But we got another lawyer who want to just give 2 minutes.
Yeah, no, I'm enjoying what we're doing here.
Yeah, go ahead, Councillor Abi. Go ahead.
Oh yeah, that's us.
What's up?
Hey Charlie, how are you?
I'm good. How you doing, man?
I'm doing good.
I still waiting for my phone call.
My man, I'm trying to find the other client to sign on for us. Dr. York's wife is contacting us to file what do you call it? To file a clemency petition for him.
So you got to pay for that. I mean, average.
For COFA?
No, Dr. York. Dr. York.
Oh, okay, yeah.
You
need to call me so we can work on. We can continue our old case.
I'll let you know. I enjoy my small brother here because I know I always follow you.
Anthony Sonwabe, what are your perspective on the Supreme Court and talk today? What do you say?
Well, look, this matter from day one. That so many Liberians call me and ask my opinion, okay? This matter is what we will call, at least in the United States, a political question matter, okay? This issue borders on a political question. And this matter is committed to an equal branch of the national government, that is the legislature.
this is a legislative matter. I have said from day one that if this was in the United States, our Supreme Court will reject it because our Supreme Court does not have jurisdiction over what happens in Congress, okay? And the same counsel, I believe, applies to Liberia because Liberia follows the state of New York. Now, the argument that Kofa has advanced is that his due process were quote-unquote violated. I don't see where his due process rights are implicated here at all, okay? This plainly and clearly a political matter. It belongs in the House of Representatives, the Supreme Court of the Republic of Liberia. You guys call them Supreme Court, I call them Supreme Corruption. For once, though, it seems that they are heading in the right direction. It doesn't matter whether they are saying is that the matter in which the majority branch handle the situation does not jive with the Constitution. It doesn't matter. What they're saying is that they don't have authority to decide this, so they're sending it back to those guys. So if our opponent go far, I will not even be declaring victory. So the Supreme Court is now ordering the majority black to go back to Congress. They're not saying that. They're saying you might not have followed your rule, but we don't have the power to tell you how to follow your rule. This issue is non-justiciable. There's no legal solution to this thing to be decided by the court.
Yeah, but
they should decide this thing on the basis of their own rule. They should go back to their house and decide it.
But the Supreme Court also said that the action of the majority is unconstitutional. What they're doing, right?
The court can say that, but the court does not have the authority to tell
So
them.
what other authority you need then?
The action is unconstitutional. But we
What authority do you need?
don't have the power.
Question, please.
Yeah, ask the question.
What authority do you need?
Yes. So, Yemen's my question to you: since this is a political case, anywhere in the world, through a political process, if someone gets hurt, how does that hurt? Get resolved? In any political matter, anywhere in the world, in hell, when there is a fight, how does it get resolved?
All for the Nkoba supporters.
I'm not hearing. Maybe someone can relate your question. I'm not.
If somebody get hurt, if somebody get hurt, so where do they seek
when someone gets hurt through a political process, where do they go for redress?
For redress.
Well, somebody, again, you should answer your own question. Somebody like who? If somebody gets hurt, if that person is not a member, if the issue is not a legislative issue, if the issue does not involve the legislature, if the issue is not the legislature taking punitive measure or action against one of its own members involving rules and regulation of that body, and outside you go to the court. But don't forget, this issue is constitutionally committed to the legislative branch of the government of Liberia. Again, the good case I would recommend for Liberia, those who know the law, my brother Jallah knows the law. Those who know the law should read Marbury versus Madison. Okay? They should read Marbury versus Madison. That's the case law that should help Liberian lawyer if they can get off their bench and do research. This issue involves a political question that involves the House of Representatives. The judiciary has no authority over this case. I think the Supreme Court is heading in the right direction. They are ruling here by ruling the way they did. What I get from the ruling is the court is saying that, look, you guys should really resolve this in your issue. We don't have the authority to tell the majority black that Kofa should return as your speaker. That's what the court is saying. And if law is a fine thing, I would just tell you this. If the so-called House of Representatives was smart enough, if they have brilliant people enough, they should have had the inclination to foresee that in the future, problems such as this could arise, and therefore they should have codified rules that will allow them to deal with this issue in their house. Is this has been in the United States? One sentence would have come from the justice in chamber. We don't have jurisdiction. Go back and resolve your issue.
So let me say this. I think you are cherry picking which laws.
I'm not gonna go because you're accusing
No,
a lawyer.
one second, please don't interrupt me, Counselor. I think the lawyer on online is cherry picking this because he just said if the representatives were smart, they would have enacted laws or rules to deal with this. But he failed to acknowledge that the very majority bloc have failed to follow the House rules.
I'm not hearing anything you're saying, my brother.
So then, I mean, only Tomalin you can hear. Then I mean, I don't understand. So there's no need.
I'll go again. Yeah, Robert, speak.
So basically, what I'm saying is, you are not. Can you hear me now, sir? Can you hear me?
Yeah.
Yeah, I can hear you now.
Okay, good. So you are acknowledging that if the House of Representatives were smart, they would have enacted rules within their body to address these issues. But you fail to acknowledge the fact that the majority bloc have failed to follow and respect the House rules and procedures in the Constitution with regards to the process of removing the Speaker. If these guys would have stayed in the main chambers, tested the strength of whatever their resolutions are, whatever their causes are to get the Speaker removed, and allow him due process, the Supreme Court will have no reason to get involved to begin with. So we are where we are right now because these lawmakers have disrespected their own rules on removing the Speaker. There are rules on the books with regards to removing the Speaker, and there are rules on the books with regards to all of these processes. They have not done that. So if you agree that the Supreme Court, by the way, Article 66 of the Constitution do give the Supreme Court authority to rule and address some of these issues as they stated today. So if you agree that their actions and their settings as per the Supreme Court ruling were wrong, and the Supreme Court does not have any jurisdiction to further instruct, then my question to you is, why should Representative Kofa not celebrate? Because Representative Kofa's contention has been, I need due process. If you allow me due process, I'll recuse myself and allow the process to play out. So if the Supreme Court agree with all of us that their process, their actions have violated the House of Representatives rules and procedures and the Constitution, then what other instruction do you need from the Supreme Court to say, you know what, these guys should do the right thing? Do you need any further instruction from the Supreme Court?
Okay, are you done?
I'm done.
Yeah, you seem to be arguing on emotion first and foremost.
No, it's not emotion. It's not emotion. It's common sense.
No.
It's common sense. No. Hey, no. Don't reduce. No, 1 second. No, sir, 1 second. Come on in. Hold on. Sir. No. I won't let that happen. This is the closing argument. We don't. I'm speaking a little louder because you could not hear me, right? I'm speaking louder because you could not hear me. I want you to respond to the question and not try to move around. Don't beat around the bush. I'm not emotional. And if you listen to this show, you will know that I've made my points not on emotion and sentiments, but on the facts. So since we're dealing with the facts, I want you to just focus on the facts. If you concur that the Supreme Court says that actions are wrong, do you need any further instructions for them to do the right thing? That's my only question to you.
Sir, first and foremost, let me let you know one thing, okay? You do not sanction how I think as an attorney and what my responses should be to your answer. Okay, you spoke, I was quiet. I believe I was civil enough. I allow you to talk, and I think you should be civil enough to allow me to speak. And don't try to speak words in my mouth. Okay?
Speaking out of, I mean, that's also not.
You just said I was speaking out of emotions. That's why I interjected. So I wanted to tell you that I'm not emotional. I'm speaking louder so you can understand what I'm saying. So let's go ahead. I will give you the opportunity to respond. Go ahead.
I don't think you're ready for a mature decision, discussion. I think you want to yell the Liberian way. That's one of the reasons why people like me.
Yeah, that's why we are unique people. You can decide
to listen. Let me challenge you then. Let me challenge you. Get off the phone. Get off the phone. Wait. Get off the phone and come on the show. Let's have a discussion. Get off the phone and come on the show. Let's have a discussion. We'll send you the link. Come on, man. Come on the show. Let's have a discussion. Would you do
told
that?
you because you are a counselor
Come on,
that
man.
makes you
Let's
better
move
than
on, man.
anybody else?
Because the man disagree
You
with
didn't
you.
come on the show. Come on the show and have a seat. Let's have a
I'm
conversation.
defending.
Instead of being emotional.
Oh, I'm a counselor. Who cares about you being a counselor? Who cares about you?
Hey, Ben.
You think this is spoon? This is the closing argument, man. We don't have dummies here. Come on the show. Let's talk.
Yo, man, Charlie, those are your small brother. Let them talk.
You will meet real men. No dummies here, man. I can show you that one.
You listening to yourself?
No, this Friday. So, yeah.
I just recorded myself.
That sound like a clown.
Yeah.
You are not
Oh yeah, if I'm a clown, then who do you think you are?
Everybody
you need to let us your end.
Understanding. I heard you rambling and rambling and rambling. So you should be civil enough to allow somebody to answer the question.
Okay, so answer the question then. Go ahead. Go ahead.
You can't pose question and then yell at the people. That's
Go ahead, answer the question. Okay, go ahead. Okay, sir, go ahead and answer the question. Go ahead.
Okay, what I try to tell you is the legislature should have had the brain from the get-go. They should have had the brain from the time that Ellen Johnson Sirleaf and the first election was held after the Civil War. Somebody should have had the vision to foresee in the future the problems such as the ones that we are facing in the House of Representatives. Therefore, as a House and as a matter of their inside internal rules, it should foresee these things in advance and map a solution to address it, keeping in mind that the political question doctrine prevents a coup, not only in Liberia, but in most democracies, from interfering, stepping into matters that involve a coordinated part of the national government, matters that are dedicated to that part of the government, irrespective of impending harms, irrespective of the notion, the cardinal legal notion of readiness. That's what I'm trying to tell you. The House is a fault for where we are. They should have foreseen the fact that certain greedy people in a corrupt society will move to remove a speaker. Why, if they don't have a quorum? Why, if the court rejects it, where do we go? These are planning that go into democratic development and democratic building. We didn't do it in Liberia. We rushed because there were money we could pay each other $200,000-300,000. Don't come here and try to lecture me. You don't know my leaning. You don't know my thinking. You assume that I'm against Kofa. I don't give a fuck about who Kofa is.
Oh, look at this. Look at this. Ethical man.
You don't know me.
Let the man go, man. Let the man go.
We are underrated, man. Let that man go. Let that man go. You see?
Okay.
Let me just say something quickly to the gentleman who dropped the line. May I just say something quickly to the gentleman who dropped the line? May I say something quickly to him? You know, I sat quietly. Oh, is he still on the line?
Yeah.
What thought he threw? No, go ahead.
I sat quietly and listened to him, and I think he shot himself in the legs when he referenced Marlboro versus Madison to be his controlling case for intervention into this discussion. Marlboro versus Madison doesn't support your argument about the court being away from interfering in other branches of the government. In fact, Marlboro versus Madison, this landmark case, it gave currency to judicial review. It's where the court demonstrated that it has the power to strike down laws and statutes that the court found to be violative of the Constitution of the United States. So if the court has that power to strike down laws from other branches of the government, how can you argue intelligently that what we see happening, the court should not have gotten involved? We're going to stop doing this. Let's not miseducate our people. Stop miseducating Liberian people.
I don't think you understand Marbury, and I don't think you know how Marbury applies.
No, but if I will correct you again, let me correct you again. Let me correct you again. I've just demolished your argument, your reference to Marbury versus Madison, which I know brought about judicial review and establishes the court authority to strike down laws from other branches. The court, even though the judicial made law, but basically the law-making authority comes from the what? The legislature. And if the court enjoys that authority to strike down laws from the legislature that are violative of the Constitution, then the court can make those kind of decisions. The other thing I will say to you here quickly, and I think we should start miseducating our people. Our court, the court just want to read one line and say we can't deal with this. No, the court can't do that because there are precedents in our jurisdiction, in our jurisprudence, where the courts have entertained issues matter of this nature. The Snow case is a case of reference. All right. So the Fonati case is not the first case wherein the court will make decision bordering the politics from the legislature. The Ase Nyenwolo case also was a case that had to do with people illegally removing the pro tempore of the Liberian Senate. The court made a decision, intervention in that case. So just come on the radio and say, oh, the court has to do it. Just going to read one sentence. I think it's unfair. Why you practice in America could be a different precedent and practice in Liberia. Our court from time to time have established a presidential force that it can intervene in matter emanating from the legislature, and their reference, their reliance have always been Article 66 and Article 2 of the Liberian Constitution.
Okay, Councilor, we got to Councilor get last statement because the guys in studio got to go home.
Let me just make the case cited by Councilor Sawabi has an ending. After dealing with the aspect of judicial review, the court said it has no authority to order the executive branch to deliver the commission that was sought. So that's why the case was cited. You need to go back.
But the review, my issue here is to bring to the public consideration the court's authority to deal with matter coming from the legislature, to strike down laws. These are laws. They make laws, right?
Actually,
I'm sorry, the guys studio got to leave.
So, I mean, man, look, for somebody to come and try to conflict the practice in the U.S. to Liberia, when there are presidential cases in Liberia to show that our Supreme Court have entertained argument for the legislature, I think it's disingenuous. It should not have done so.
We gotta go.
Jallah, thank you so much. I just thanks a lot because the guys in the studio at 1 o'clock in Liberia got to go home.
So thank you very much. Thank you very much. Thank you very much. But again, bird of the same feather flock together. Councilor JY friend here, friend rolling together. Thank you, gentlemen. Thank you, gentlemen.